Ms. or Maweni. The Registrar Clerk.
Judge Majid. Oh.
Yes, Ms. Maweni.
Good morning. I am the Registrar Clerk for this hearing. Justices of the Constitutional Court, all counsel are online. I call the matter of the South African Human Rights Commission and the Standard Bank of South Africa Limited and others for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
Yes.
Justices, I appear on behalf of the applicant for leave to appeal, together with my learned friends, Ms. Weber and Ms. Makapela.
Thank you, Mr. Chaskalson.
Thank you, Justice Madlanga and Justices of the Court. I'm Kate Hofmeyer. I appear with my learned friend, Mr. Nkonko, for the first respondent, the Standard Bank of South Africa.
Thank you, Ms. Hofmeyer.
May it please the Court, together with my learned friend, Mr. Lutuli, I appear for the second respondent, that is Nedbank.
Thank you, Mr. Cockrell.
Thank you, Justice Madlanga and other members of the Court. Together with my learned junior, Mr. Ellis, I appear for First Rand Bank, the third respondent.
Thank you, Mr. Cillier.
May it please the Court. Justices, I'm Abram Lowe from the Pretoria Bar, appearing together with Mr. Stephen Davies and Ms. Simone van der Walt for the amicus curiae.
Thank you, Mr. Lowe. Yes, Mr. Chaskalson.
Thank you, Justice Madlanga. Justices, this case raises two fundamentally important issues of substance. The first is the mandatory jurisdiction question. Is the High Court obliged to exercise the jurisdiction conferred on it by the Constitution and the Superior Courts Act, or does it have a discretion not to exercise that jurisdiction in relation to matters which fall within the Magistrates Courts jurisdiction? The second issue of substance is the access to court question, which is the fundamental right of access to court implicated by the practice of banks and other powerful litigants of running their routine debt collection processes out of the High Court rather than the Magistrates Courts in respect of amounts which fall within the jurisdiction of the Magistrates Court. The South African Human Rights Commission first became involved in this case as an amicus in response to an invitation from the High Court. It then successfully applied to be an amicus in the Supreme Court of Appeal. In the proceedings before both the High Court and the Supreme Court of Appeal, the individual respondents have not actively opposed the position of the banks in relation to the two important issues of substance raised by the case. We do not know why this is so, but it may be related to the fact that by the time that the hearings took place, in 7 of the 12 individual cases, the banks had withdrawn their applications for default judgment. In 1 of the remaining 5, it was clear that the matter did not fall within the jurisdiction of the Magistrates Court, so the questions didn't really arise. And in the remaining 4, we don't know what the situation is. It may well be that the remaining 4 of the original 12 respondents may not have been in a position to advance any defense to the claims of the banks. Be that as it may, it was only the Human Rights Commission that advanced any submissions contrary to those of the banks before the High Court and the Supreme Court of Appeal. So when the Supreme Court of Appeal handed down judgment in favor of the banks, there was no prospect of any of the respondents applying to this court for leave to appeal. And those two fundamentally important issues of substance that are raised by this matter would have been finally determined for the foreseeable future in a judgment binding on all high courts without the involvement of this court. In these extraordinary circumstances, although the Human Rights Commission had hitherto only been an amicus in the proceedings, it applied for leave to appeal to this court so that the two crucial issues raised by these matters could be determined by this court as the highest court in the land. Now, alongside the issues of substance, there are some issues of form raised by this application. Was the Gauteng High Court order appropriately formulated? What is the effect of the South African Human Rights Commission applying for leave to appeal only against the decision of the SCA in respect of the Gauteng High Court matter, not in respect of the Eastern Cape matter? Is the South African Human Rights Commission bound to ask for the Gauteng High Court order to be reinstated? These are issues of form, but the underlying issues in the application, the issues of substance, are constitutional issues of material public interest, and they will not go away. They are questions which ought to be determined by this court. They've now been the subject of carefully considered judgments of both the High Court and the Supreme Court of Appeal. And in view of the Supreme Court of Appeal judgment, it's difficult to see how these questions will ever reach this court again, other than in the present case. So whatever this court ultimately makes of the appeal in relation to the formal questions presented by the Human Rights Commission application for leave to appeal, we would urge this court not to avoid engaging with the two crucial questions of substance raised by this matter. They are critical questions. They are questions which call for a decision of this court, and absent a decision in this matter, it's difficult to see how they will reach this court again. I propose to structure my oral submissions as follows. First, I want to make some observations about the facts of the 12 individual cases that precipitated the hearing in the Gauteng High Court, because these facts are relevant to both the mandatory jurisdiction question and the access to court question. Then I will consider the mandatory jurisdiction question. I'll then move to the access to court question. And finally, I will address the issue of an appropriate order, and to the extent necessary, respond to the formal issues raised by the respondents in that context. To start then with the 12 cases, they are set out in a table at page 25 of our heads. And to begin with, I would ask this court to ignore the second case on that table, the Inquinica matter. It can be ignored because it didn't fall within the jurisdiction of the Magistrates Court. The amount claimed in that case was 622,000 rands, which was above the then Magistrates Court limit. So we're left with 11. The first point to be made about these matters is the point that we make at the top of page 25 of the heads. They were all applications that were brought by banks that sought default judgment against the debtor, as well as an order declaring each debtor's home specially executable. The amounts in arrears were relatively small, yet the debtors had apparently been unable to pay these amounts despite the threat of losing their homes. If we take out Inquinica, the highest amount of the alleged arrears was 20,782 claimed in the Lempe case, and the alleged arrears went down as low as 7,271 in the Langbian case. So if on the bank's version, we're dealing with a defendant who's unable to pay 7,271 rands to save his or her home, we are dealing with a defendant who has very limited financial means. The second point that I want to emphasize is one that's not made in the heads. And it's the point that in 7 of the 11 remaining cases, after the High Court directive was issued and the matters were given special attention, the banks no longer persisted in their applications for default judgment against those 7 respondents. And if I can take you through the table and give you the references to the record in this regard. The first case on the table at page 25 is Mpongo. And there you will see that this application was withdrawn because the respondent settled the arrears. The reference there is volume 1, page 97, paragraph 35.1. Then in Inquinica, which we discussed, it should be ignored. It didn't fall within the Magistrates Court's jurisdiction. Then Lempe. Lempe is a case in which the Standard Bank continued to pursue the default judgment application. Wudita Prasad, that case was also withdrawn because an agreement was reached to bring the arrears up to date. There we see you'll see from volume 1, page 97, paragraph 35.2. Goeieman was a case which Standard Bank persisted with. Iguilo, the ABSA case, was withdrawn. That, I'm afraid, is not, due to an error in the assembling of this record, was not, the relevant allegation doesn't appear in this record. It appeared at page 293, paragraph 3 of the High Court record. Pillay was a matter which ABSA pursued. Sonkor was a matter which Nedbank pursued. Tobajani, you'll see from volume 2, page 167, paragraph 59, that Tobajani settled the arrears and the proceedings, according to Nedbank, were left in abeyance. Mahlangu was withdrawn. And the last three, the F&B three, were all withdrawn because clients discharged the arrears, and the letter confirming that fact is at volume 2, page 189. So in 7 of the 11 cases, there was ultimately a withdrawal of the application for default judgment. And even if the debtors had no defense to the claim for arrears, they apparently did have a defense to the claim for an order declaring their homes executable. That defense was, it's not necessary to take my home away from me to recover your arrears. I can restructure, let's restructure my affairs so that I can pay your arrears. What that means is that absent the High Court directive, default judgment would probably have been given on orders declaring debtors' homes executable when there was a defense against such an order. So absent the High Court directive, it's likely that the fundamental right to housing would unnecessarily have been impaired in a default judgment. And that has obvious implications for the access to court issue. There are 7 cases where a judgment would have been handed down unopposed, where there was apparently an answer, and that answer would have stopped the debtors' homes being executed or declared executable.
At that point, Mrs. Shaskelson, colleagues may now put questions to you. Please continue.
Thank you, Justice Madlanga. But quite aside from the access to court issue, absent the High Court directive, in 7 out of the 11 cases, a High Court judge would have had to devote time and thought to the question whether it was appropriate to declare the debtors' homes executable, when it turned out that there was no need for High Court time to be wasted on that inquiry. And we submit that that is relevant to the judicial independence aspect of the mandatory jurisdiction issue. Before we get to this aspect of the mandatory jurisdiction issue, it's necessary to consider the constitutional and statutory framework within which that issue has to be considered. Justice Tron.
If the defendants had a defense and if there was no reason to proceed, that would be so in the Magistrates Court or in the High Court. What is the point you wish to make about that?
Well, we don't know why. We know why the defendants. What happened in this case is that the defendants didn't appear in the High Court. We don't know why they didn't appear in the High Court. We do know that at least in 7 cases there appears to have been a substantive defense that they could have advanced. When we get to the access to court issue, we will submit that there are far greater barriers to getting a defendant before court to advance the case that they have at their disposal in the High Court than they are in the Magistrates Court. So I can't in good faith stand before this court and say, well, if they'd sued in the Magistrates Court, the defendants would have been there and would have advanced their defenses. On the facts, I can't say whether that would have happened or wouldn't have happened. But we're talking here about a systemic issue that's gone way beyond the individual 7 defendants, and is now, at least in terms of the orders handed down by the Gauteng Court and the SCA, going to govern the approach of courts to all of these matters.
Mr. Chaskalson, excuse me.
Sorry, Mr. Justice Matoko, can I simply conclude my answer to Justice Turon before taking your question?
Yes, it's a follow-up to that question.
If I can just simply finish off what I was going to say, because it's a systemic issue that we're dealing with, our submission is that because of the greater barriers of access to court at High Court than Magistrates Court, this court and indeed the High Courts should be having regard to that in relation to how they exercise their discretion, whether to take these cases or not. But I'll get back to that in much greater detail when we deal with the access to court issue. Sorry, Justice McLaughlin.
Okay, does the fact that the facts that you are now advancing were not pleaded have anything bearing at all with your submission?
Pleaded in the
where? Yeah.
They were certainly they were certainly ventilated in the High Court. I mean, they were ventilated at length in the High Court by us. I've got my notes from that hearing, and it is a point that I specifically made before the High Court, that in 7 of the 11 cases, there was a defense to the order declaring the property executable. We were only an amicus, so we could never plead facts in the way that a party could. And the parties, of course, were not participating in the High Court hearing.
I'm just worried about the way the High Court dealt with the issues. I know somewhere in the judgment of Tolmay, mention is made of the fact that the respondents, the debtors, let me put it that way, were invited to participate and did not participate. I don't want to say chose not to participate. As you correctly say, there could be a lot of factors attributed to that. My worry is absent that evidence, and which seem to have formed the bedrock of the judgment of the High Court. Can one make a informed decision that had the matter been litigated in the Magistrate Court, the debtors would have availed themselves of that opportunity, appeared and defended and raised the issues that they would have raised, which somehow led to the withdrawal, i.e. and settlement of the case? Do we know or we don't?
Well, the individual debtors have not put those facts before court. So we don't know in the case of the individual debtors. I can't say to you that these individual debtors would have appeared in the match court if these matters were sued out in the match court. I can't make that submission. The submission that I can make is twofold. The first is that it is alarming that in 7 out of 11 cases, there was a defense that would have saved a family home that wasn't articulated in a High Court case. That's the first proposition. And that does raise questions of access to court. The second is that if we look objectively, there are far greater barriers to litigants seeking to defend claims in the High Court than there are in the Magistrates Court. And what we make of those facts is a matter that I would want to address later in the submissions when I come to the access to court argument.
As I understand it, sorry, as I understand it, whatever way we look at it, access to court plays a pivotal role in the determination of this case. If one looks at the amounts that were asked or claimed by the bank, there are paltry amounts which on your submission and in your heads you say should not engage the attention of the courts. And for us, the attention of the High Court, sorry. And for us to make a proper determination, we have to look at the mandatory jurisdiction vis-a-vis the access to courts. And Okay.
I agree completely, Justice Matopo, which is why I want to start first with the mandatory jurisdiction question.
Okay.
And that's a question that that we address.
Oh,
Sorry, Justice Mplaza.
oh, okay. You may go ahead, my sister.
Thank you.
I'm sorry, on the Zoom. Oh, Justice Chief. Sorry, I didn't see you on the Zoom.
Oh, okay. Thank you. It's okay. Before you go to the mandatory jurisdiction point, I just want to clear something about the concurrent jurisdiction point. Do you accept that the High Court has got concurrent jurisdiction with the Magistrates Court?
Absolutely, and I do want to emphasize in that regard that we're not submitting at all that the High Court doesn't have jurisdiction over these matters. Our argument is pitched merely at the level of whether the High Court has a discretion not to exercise that jurisdiction, which it has.
Okay, all right. Why, what? You see, what confuses me about this case, and I've looked at your heads where you said that, where you say that in certain circumstances, the High Court may refuse to hear a matter. Did I understand you well in your heads when you say that the High Court may refuse to hear a matter?
Indeed, a matter falling within its jurisdiction. Yes, Justice, that is our submission.
Do you consider what is your submission concerning what the radio in AgriWire?
Well, AgriWire is definitely against us on that, but AgriWire is not binding on this court, and our submission is that AgriWire is wrong, both generally and also specifically in relation to cases where the fundamental right of access to court would be implicated. So the general submission, the general attack on AgriWire—
I'd like you to unpack that.
Certainly. So the general submissions in relation to AgriWire go to the general submissions on why the mandatory jurisdiction principle hasn't survived the Constitution, and that's a topic that I would that I'll address in some detail now. But before I do so, I want to submit that even if AgriWire were to be right on the general principle, it could never be suggested that a High Court, which is bound by the Bill of Rights, could ever exercise jurisdiction in a matter where it is clear that to do so would violate a litigant's right of access to court. And let me give you an extreme example, which is not an unopposed case, it's an opposed case, so the facts will be before the court. Let's take the biggest province, the Northern Cape, and let's assume that there is a matter, an opposed matter is instituted out of the High Court in Kimberley in respect of a matter within the jurisdiction of a magistrates court 500 kilometers away. And on the first day of the hearing, the defendant comes to court and says, I want to oppose this matter. I have a proper defense. I can't afford to pay lawyers. I can't afford to pay for accommodation and transport expenses to travel hundreds of kilometers from my home to appear in person to defend my case. So if you insist on hearing this case in Kimberley, I will not be able to defend myself. And this case will have to be taken against me by default judgment. But there's no good reason why this case can't be heard in the magistrates court 2 kilometers away from my home. I want it to be heard there. Now, on those facts, we submit that it could never be suggested that the Kimberley High Court was obliged by the mandatory jurisdiction principle to say, sorry, I have to exercise my jurisdiction once the plaintiff has chosen to bring this court to me, and therefore I'm going to press ahead, and I know even if that means that default judgment will have to be given against you. So that would be a case where where even if the mandatory jurisdiction principle was correct as a starting point, it would have to yield to the fundamental right of access to court on the facts of a specific case. And in that respect, when we come back to the order of the SCA, we will submit that the order of the SCA on any scenario goes too far, because it doesn't recognize that the mandatory jurisdiction principle has to yield to the fundamental right of access to court where a factual case has been made out in respect of the fundamental right of access to court. But we in fact submit that the mandatory jurisdiction principle itself is a pre-constitutional rule of the common law which did not survive the Constitution. And that's a much more fundamental attack on AgriWire. And if I can address those submissions now, because those are core submissions that we make.
Well, you can, and I think that in the process of doing so, you will also address us, because you're saying that those are pre-constitutional principles. I guess then you will have to address us on 169(1) of the Constitution as well. The other point I would like you to address when dealing with this is whether an award of costs against a party that institutes proceedings that where the Magistrates Court has got concurrent jurisdiction is not adequate.
If I can take the second question first. The award of costs we submit is not adequate. And let me stay with that extreme example that I previously articulated in relation to the notional case brought in Kimberley from against a defendant 500 kilometers away. In that situation, an order of cost is going to be cold comfort to the defendant who notionally had a defense, but because of the impossibility, the financial impossibility to that defendant of advancing the defense in the Kimberley High Court, was never able to advance it. So costs won't cure the access to court problem. We also submit that in relation to the issues of judicial control of High Court control of High Court roles, costs orders may be insufficient. If litigants, take the banks in this case, the banks bring the matters to the High Court for small amounts, 7,000 rands, engage the time of the High Court and High Court judges to deal with these matters. There has long been a principle that you can, order costs either only on the Magistrates Court scale or against the applicant who brings these proceedings. But it's clear from the judgment of the Gauteng High Court that that's not serving a deterrent effect. But the central argument in relation to mandatory jurisdiction starts from section 169, and it
before you move there, let me just take up an issue that relates to my sister Justice Chikri's question. Assuming that the High Court does indeed have a discretion, why, if for example we are to focus on the Northern Cape example that you have given, why must the exercise of the discretion have the effect of creating a rule that applies across the board? Why must the discretion not be applied on a case-by-case basis? Maybe asking the question differently, is the effect of what the applicant is asking for, not the creation of a new substantive rule.
Justice Madlanga,
there are three related questions, or three related questions in there. Basically one, but yeah.
So in the Northern Cape case, in any opposed application, one can exercise this discretion on a case-by-case basis, because the litigant who complains about the access to court issue will be there before the court can make the complaint, can put the facts before the court. The problem in these cases is that there are default judgments, so the litigant is not there. And so one doesn't know why the litigant is not there. Is the litigant not there, one, because the litigant has no defense at all? Or two, is it because the litigant has a defense, but is scared away from the cost of advancing, it can't lay out the cost of advancing that defense in the High Court, or in any court, or is intimidated by courts, away from courts? Or three, the litigant may be able to advance that defense locally at a magistrates court, but not centrally at a high court, where it's more expensive, it's further away, they're greater costs. Now, in the default judgment case, we don't know the answer to those questions. So if the court is going to exercise any discretion, it's going to have to do so in a way which may create at the very least a default rule, because it can't say, well, we'll wait to hear what the defendant has to say. By definition, the defendant is not going to be there to say it. And that's why I keep on coming back to the extraordinary feature of these cases, which is that in 7 out of 11, there was a substantive defense to the claim to declare the home executable. And that never would have come before the court, but for the fact that some special attention was paid. So there is a problem. And the real question is how the courts should address that problem. But there is a separate issue, Justice Madlanga, which goes to the mandatory jurisdiction principle, which is there's the problem of access to court, but there's also the problem of the use of judicial resources. Because, I mean, for all of us who argued in front of the High Court, it was quite clear that what animated that judgment was...
Justice Madlanga, are you done with the question?
No, I just wanted, Mr. Shaskarson, may I come in? I did not come in, my sister, because I thought Mr. Shaskarson was moving to a second related issue, still answering my question. Am I correct, Mr. Shaskarson, or not?
Absolutely, Justice Madlanga.
Thank you.
Yes, then, thank you.
So the second related issue is the judicial control of judicial roles issue, because and what I was submitting is it is clear to those of us who argued the High Court matter that there were concerns about access to court, but there were also concerns about tying up High Court judges with hundreds upon hundreds of default judgment applications on a weekly basis. And that is a very serious issue relating to the administration of justice, and we submit to the institutional independence of the judiciary. It's not a rational use of judicial...
Just on that point, and how were the parties expected to deal with it? Because that was evidence given unusually by the judge. Tolmay J actually gave that evidence. And Sutherland AJA actually highlights that more than once, that the judge testified quite extensively, and where the parties expected to on appeal seek to lead to introduce new evidence countering what the judge had done. And was it even proper for the judge to testify in her judgment?
I don't want to answer that question, Justice Madlanga. This court can make its own can draw its own conclusions. But the issue of principle, if we keep it away from the specific facts that found their way into the High Court judgment, is a serious one. There are very limited judicial resources in this country. High Court judges are superior court judges who go through a rigorous screening at the Judicial Services Commission, who are picked on their basis, on the basis that they have the legal skills necessary to handle the types of disputes that come to the High Court. If those judges are going to be spending a substantial portion of their time doing jobs that really ought to be handled at magistrates courts level, then it's an irrational use of judicial resources. And that, we submit, does implicate independence of the judiciary. It also implicates access to court for everyone other than the banks, who then, have less available court time, because so much of the resources of the High Court are being devoted to cases which ought really to be dealt with elsewhere. Let me take you back to the first leg of your response. You say in the Northern Cape example, we do know, because the litigant will say, because of the 500-kilometer distance, I will not be able to defend this matter, and therefore I'm not entering the fray. And you say, with regard to the rest, we do not know. Weren't there ways in which, for purposes of this litigation, information could have been sourced as to why that is so that we could then deal with concrete facts / statistics which set out the reasons why? Why must we speculatively, as it were, make certain assumptions? I should not be seen to be sitting on an ivory tower and not being aware of the disadvantage that our people suffer. I'm well aware. But for purposes of litigation, shouldn't that sort of information have been sought? And, I'm aware how the applicant came to participate in these proceedings. I don't think it can be said that the applicant was so pressed for time that it could not have sought extensions and so on, and explain what sort of information it seeks to lay its hands on, and then bring that information forth. And we would not be in the realm of speculation, which we now find ourselves in. Justice Madlanga, I can't offer a proper defense of to that problem at the question of fact. I do want to get back to the question of law, though, on the mandatory jurisdiction, and just to fill the court in on what actually happened. It was the intention of the Human Rights Commission to conduct scientific surveys to try to establish these facts, put them before the court. Ultimately, it was not able to do so. It conducted some surveys. The validity of those surveys was challenged by the banks. I think the Human Rights Commission accepted that the surveys that it had conducted were the admissibility of that evidence was properly targeted by the banks, and so it didn't persist with those, and so we ended up in a situation where there was no admissible statistical evidence to be able to inform the court with any degree of certainty as to what motivates respondents who default in high court proceedings, whether and in particular whether magistrates courts hearings would precipitate a much higher response rate. But there is a separate issue, which is the legal question in relation to the mandatory jurisdiction principle.
I'm done, my sister, Justice.
Thank you, Justice Madlanga. My question is linked to the point that you are going to raise now. Bearing in mind that the High Court has concurrent jurisdiction with the Magistrates Court in certain matters, what I would like to know is twofold. First, the interpretation of the word may in section 169, that's the section that you rely on for your argument. And the second part is, how is this going to be done? How will the High Court then tell the party litigant that has decided to launch its case in the High Court? Just explain to me how would that be done in terms of telling that litigant to go to the Magistrates Court when an application has been launched in the High Court?
Well, the first question is that the starting point is 169.1, which vests the jurisdiction of the High Court, the original jurisdiction of the High Court. And that jurisdiction is framed in terms which says the High Court may decide certain matters, not must. So the Constitution itself chooses language which doesn't impose an obligatory jurisdiction on the High Court. It vests it with jurisdiction, but it does so in permissive terms, which on the simple interpretation of 169.1 would allow the High Court in appropriate circumstances to decline to exercise that jurisdiction. So that's the Constitution. There's no statute that says the High Court must exercise the jurisdiction that it is conferred with. Chapter 6 of the Superior Courts Act, which deals with jurisdiction of the High Court, has no provisions that oblige the High Court to exercise jurisdiction it may have over any particular matter. And if we go back to the Constitution uses may when it confers jurisdiction on the High Court, on the Supreme Court of Appeal, and on this court. And the suggestion of the respondents that may means must, that when you see the Constitution say the High Court may do this, means it must do this, would then mean that this court similarly is obliged to exercise the jurisdiction that the Constitutional Court vests in it in all cases. But we know that that's not the case. In that regard, the obvious example is this court's use of the interests of justice test to decide whether or not to hear appeals, and not just appeals which are direct appeals, which may be limited to interests of justice under, I think it's 167, sorry, I've lost my reference. The 167.6, which says national legislation or the rules of the Constitutional Court must allow a person, when it's in the interest of justice and with leave of the Constitutional Court, to appeal directly to the Constitutional Court from any other court. So an ordinary appeal from the Supreme Court of Appeal, which is not a direct appeal, is still governed by that interests of justice text. That's because the jurisdiction conferred on this court is a permissive jurisdiction. This court can decline to exercise that jurisdiction in appropriate cases. It's used that interests of justice standard to exercise its discretion on whether or not to exercise jurisdiction. And the most recent judgment which illustrates this proposition, to which we'd refer, it's not in our heads, it's Paulson versus Slipknot, which was a suggestion that where this court had to engage interests of justice to say it's got a discretion. It doesn't have to hear every single matter. And if I can quote from paragraph 29, wherein an application for leave to appeal founded on a constitutional matter, this court holds there is indeed a constitutional issue, that does not automatically lead to the grant of leave. This court has a discretion, and on this, the fundamental criterion is the interest of justice. in Busak, we held a threshold requirement in leave to appeal relates to the issue of jurisdiction. The issues to be decided must be constitutional matters or issues connected with decisions on constitutional matters. This matter is dealt with more fully below. A finding that a matter is a constitutional issue is not decisive. Leave may be refused if it is not in the interests of justice that the court should hear the appeal. So we have a situation where this court has a controlling power to decide which matters within its jurisdiction it will entertain. And we submit that if one goes back to the Constitution, the empowering jurisdictional clause 167, which vests this court with its jurisdiction, uses the same word may that 169 uses in the High Court. And by parity of reasoning, you can't have a mandatory jurisdiction principle for the High Court if you're not going to accept a mandatory jurisdiction principle for the Constitutional Court. And there isn't a mandatory jurisdictional principle for the Constitutional Court with very good cause. And we submit, by the same token, there shouldn't be a mandatory jurisdiction principle for the High Court. And
Mr. Chaskelson, if my sister...
That's the last point on that aspect. So what would happen then would be in a case where a case falling within the monetary jurisdiction of the Magistrates Court, the High Court will then decline to hear the matter. Would it then transfer it on its own, or would it be a dismissal, leaving to the litigant to then decide whether to go to the Magistrates Court or not?
Justice Mhlantla, I'm not suggesting that in all cases the High Court would decline. It's not as though the High Court has no jurisdiction over those matters. It has those jurisdictions. We submit it would have a judicial discretion not to exercise the jurisdiction. And that judicial discretion would have to be exercised judicially. In particular, it could never be exercised in relation to a matter where to refuse to hear the case would be to deprive the plaintiff of access to court. If, for example, if one looks at some of the allegations of the banks, if essentially what the High Court would be saying is, go, I'm not hearing this, you must go to that Magistrates Court, and the bank could show that the Magistrates Court with jurisdiction was dysfunctional, well, then the effect of the High Court refusing to entertain jurisdiction on the facts of those cases would be to deny access to justice, because it's no solution to say, I'm not going to hear it, go to a dysfunctional court. But in cases where there is a functional Magistrates Court, then our submission is that the High Court has a judicial discretion to decline to exercise jurisdiction. And it will obviously be guided. If there are access to justice issues, those must be paramount, because those are fundamental rights that are binding on the High Court. But it needn't only be access to justice issues in the ordinary sense. You could also have a situation where the High Court, perfectly reasonably through the exercise of a judicial discretion, says, I am going to decline to exercise my jurisdiction over these unopposed debt collection matters that fall within the jurisdiction of the High Court, because the effect of that is to clog up my rolls, to deprive litigants who have to come to the High Court, who have to take advantage of the specialist expertise of High Court judges, of access to High Court judges. And these matters can and should more appropriately be dealt with at Magistrates Court level. So we're submitting that what we're talking about is a judicial discretion that has to be exercised judicially. It's not only in cases where you can prove that to exercise jurisdiction over this case, like our hypothetical Northern Cape Kimberley example, would be to violate the fundamental right of access to court. It can also be for any reasonable judicial imperative, like ensuring that judicial resources are used in the most rational way. How it would play out, Justice Nklandla, I'm not sure, and I'm not asking this court to pronounce in that regard. One possibility is it may be that mero motu the court could refer it to the Magistrates Court. Another possibility would be the court could just strike the matter from the roll and then leave it to the litigant to decide how to go further. Justice Madlanga earlier asked me, aren't I suggesting that they need, do my submissions not lead to the situation where there's going to be almost a new rule, a kind of a generalized legislative?
Mr. Chaskelson, perhaps before you get there, if I may follow up on some of the submissions you have made regarding judicial discretion and the discretion which this court exercises, whether it should hear a matter and whether it's in the interest of justice to entertain a matter. Now, we accept that in the matter before us, the High Court had jurisdiction. And you made the example with the Constitutional Court having jurisdiction, but then going to decide whether it's in the interest of justice to entertain that matter. That exercise this court performs on a case-by-case basis, whether having regard to the facts of a particular case, to the issues related thereto, whether it would be in the interest of justice to hear the matter. It's not a blanket refusal to entertain certain kinds of matters, which is what it appears was done in the High Court. So there is a distinction.
I readily accept that, Justice Drawn, but and I would, for the purposes of my argument, I would emphasize that what the order of the Supreme Court of Appeal would preclude the exercise of any such discretion. The order of the Supreme Court of Appeal says you may not refuse to exercise jurisdiction over a matter that comes to you and falls within the concurrent jurisdiction of the Magistrates Court. So in that respect, my submission is that even if we are confined to case-by-case exercises of judicial discretion, the order of the Supreme Court of Appeal goes too far.
But we already have practical examples, Mr. Chaskelson. I forget the name of the case now that related to children who, I'm not sure it was custody, but they were in Switzerland. Yeah. So already a court has the power to say, this court has jurisdiction in this matter, but on the facts of this case, it's not in the interest of justice to hear it. So we have precedent for that already.
But that, indeed, Justice Drawn, but I do want to emphasize that the Supreme Court of Appeal order would appear to override that precedent in the opposite direction. So if we look at that order, and it's at volume 6, page 500, it's taking away that discretion to deal with cases on a case-by-case basis. Paragraph 1 of that order says the High Court must entertain matters within its territorial jurisdiction that fall within the jurisdiction of the Magistrates Court if brought before it, because it has concurrent jurisdiction with the Magistrates Court. Must, not has a discretion not to.
But wouldn't it be entertaining the matter, hearing the matter, and then deciding that it's in the best interest that another court determine that? Wouldn't that be entertaining the matter? And its conclusion being that having entertained, having looked at the facts, it's in the best interest that another court deal with it.
Well, if the court wants to clarify that, we would be grateful, because our reading of orders 1 and 2 of the Supreme Court of Appeal order is to preclude any refusal to determine a matter on the grounds that it would be better determined in the Magistrates Court. But there remains the case-by-case assessment can only work where there is a defendant before you, where you can get facts out of a defendant. And that the problem of the unrepresented defendant doesn't lend itself to a case-by-case judicial discretion. And in that regard, we submit that it would be perfectly permissible for the High Court to establish almost a default principle that if you as litigant want to bring before us a case that falls within the Magistrates Court's jurisdiction and it is unopposed, you need to persuade us that there is a reason why we should hear this case. Because, and that reason may relate to the complexity of the matter. It may relate also to the dysfunctionality of the Magistrates Court with jurisdiction. But if you don't do that, if such a rule would be impermissible, then you cannot then there's no way for a court to exercise judicial discretion in relation to those cases. And there's no ways for the High Court to control its roles in a way that most rationally allocates judicial resources. It's
Mr.
a very serious...
Mr. Chasker, my sister has completed her question. I wonder whether I might ask a question flowing from what you've just said. It strikes me that a good deal of the challenge that you bring to this court is actually directed at the statutory scheme of concurrency, rather than, as you do, accepting the scheme of concurrency which Parliament has dictated and now seeking to have outcomes regulated by either a default rule or a discretionary exercise of jurisdiction.
There can be no challenge to a statutory scheme of concurrency because the Constitution contemplates that there will be concurrency. It gives the High Court jurisdiction.
Why? It's an incident of what Parliament decides. The Parliament can take away jurisdiction under the Constitution. It's a function of statutory choice. And so you may be right that there could be a challenge to say the choices made by Parliament impact adversely on access to justice. But you are seeking to invent that or reinvent that kind of challenge at the level of saying this court should determine a default rule in favor of the Magistrates Court. And I'm wondering where we obtain that power.
I'm not saying that this court should do it. I'm saying that it should be open to a High Court, to each High Court to...
But Mr. Chasterson, you're not really saying that, because save in the unusual circumstances where the defendant actually comes to court, you're saying that you can't really have a case-by-case determination. There should be what you've called, I think accurately, for the purposes of your argument, a default rule. In other words, a substantive rule of jurisdiction that says High Courts will ordinarily defer to Magistrates Courts unless there is a good reason to accept jurisdiction. Now, where do we get that from?
Well, to start first with your earlier question, which is slightly different, am I challenging the statutory framework? I'm not challenging the statutory framework, and there's nothing in the statutory framework. And I think it's a very important submission that I must emphasize. There's nothing in the statutory framework that prescribes mandatory jurisdiction. That's not there in the wording of any of these statutes. That's something superimposed on the statutory jurisdiction by not even judicial interpretation, a law of the common law.
But is even that proposition correct? Because the use of the word may, as courts have often said, can have two meanings, but one is simply to confer a power. It's not saying we confer the power and we give you a discretion as to whether to exercise it. We simply confer the power.
Indeed, but one has to read the judiciary chapter of the Constitution consistently. So if the mandatory jurisdiction principle applies to the High Court, it's going to have to apply to the SCA. It's also going to have to apply to the Constitutional Court. And plainly, it doesn't apply to the Constitution.
No, but if I may, and this will be my last question, I'm not certain that the distinction you're drawing is correct as between jurisdictional considerations and questions around leave to appeal. Again, there's a distinction between whether a court has a jurisdiction to entertain a matter, and quite separate and indeed regulated under statute and rules is the separate question where a court having jurisdiction is granted the power to decide whether to hear an appeal or not. They're not the same questions. I think you're eliding those questions.
It's a direct access, but then we can talk about direct access. This court has jurisdiction. It won't to entertain matters as court of first instance. It's not just an appellate court. It won't exercise that jurisdiction unless it's in the interest of justice to do so.
Yes, because in addition to its jurisdictional question is a separate power to determine whether to entertain a matter, either on appeal or by way of direct access. I don't think you can correctly characterize that power as jurisdictional. It's simply a power that is given in the exercise of a jurisdiction that is accepted, as opposed to a circumstance where you have no jurisdiction at all.
I've lost you on that distinction, but let me. If I go back to the submission that there is no statute that obliges this court, or the High Court, to exercise its jurisdiction in every matter over which it has jurisdiction. There is no statute that does so. And then, at the very least, the High Court would have the inherent jurisdiction under Section 173 of the Constitution to protect its own process by saying, we're not going to let 60% of our time be wasted on dealing with default judgments that should be in the Magistrates Court. That would be a power under Section 173.
And just apropos this, and then I'll thank you, Justice Madlanga. My questions are asked. But isn't there a very considerable danger in rendering jurisdictional questions subject to case-by-case discretionary decision-making? You can just imagine what's going to happen in the courts. Every single case will begin with some investigation on whether discretion should be exercised in respect of taking jurisdiction or not taking jurisdiction. In other circumstances, forum non-convenience, comity, and so on, those are exceptional circumstances for declining jurisdiction against the rule of accepting it. But you would reverse that and say, well, no, actually, the High Court should standardly decline it unless there is a discretion to be exercised to accept it. And you can just imagine what's going to happen to jurisdiction under discretionary decision-making.
But you have to look at what happens currently. I mean, currently what happens is an inordinate amount of High Court judge time is spent dealing with default judgment applications on matters that fall within the Magistrates Court.
Hence the need for statutory or rule-based intervention.
Our submission is that it would be perfectly permissible for a rule in the form of a practice directive in a division to be issued to this effect. But such a rule wouldn't be competent under the terms of this current Supreme Court of Appeal order, because the Supreme Court of Appeal says you as the judiciary cannot make such a rule because you as the High Court are obliged to hear everything. And what we certainly in the Supreme Court of Appeal hearing, we readily accepted that the effect of the High Court order was more or less legislative, and it was probably not appropriate for the High Court to legislate that way, and it would probably be better dealt with in the form of a practice direction, which would then form a rule for the local division, which would have local legislative effect, or within a division have legislative effect.
Thank you, Justice Madlanga.
May I just follow up on that, please, Mr. Chaskalson? You draw the distinction between this court and the High Court, but it seems to me the interest of justice derives directly from Section 1676, which says that national legislation or the rules of the Constitutional Court must allow a person when it's in the interest of justice and with leave of the Constitutional Court, firstly to bring a matter directly to the court or to appeal directly from another court. So the interest of justice criterion is not really a sound basis for drawing that distinction, isn't it? Because the Constitution itself makes provision for that extra level to be added in terms of the general jurisdiction criterion, isn't it?
Justice Majid, it's not a jurisdictional requirement imposed by the Constitution. It's saying that as a bare minimum, when it is in the interests of justice for you to appeal directly to this court, you must have that right. It's not saying that that this court doesn't have jurisdiction absent the interests of justice.
No, I think we're at cross purposes. I'm saying to you that there's a general jurisdiction clause in the Constitution, but then it adds for these special cases, in exceptional cases where it's in the interest of justice to do so, a litigant may approach the court directly or may appeal directly. So isn't that distinction that you try to draw, isn't there a distinction that the Constitution draws between the High Court and this court? Because you say if a High Court doesn't have that discretion, then what about the Constitutional Court? And the answer is in 1676 as I see it. Not so?
With respect, not, Justice Majid, because what 1676 is doing is ensuring that when a litigant can show that it is in the interests of justice, this court will be obliged to entertain the appeal. It's not saying this court doesn't have jurisdiction absent the interests of justice.
Well, I'll leave that there because I don't think we'll reach consensus on that one. Can I ask you, one of the few startling features of this High Court judgment, of the full court judgment, is the notion that the concept of a plaintiff or an applicant being dominus litis is quote unquote outdated. Surely you don't subscribe to that observation, Mr. Chaskalson. I found it quite disconcerting. Because as Sutherland AJA says, a cricket match must start with the first ball being bowled. The batsman can't do anything. The tennis player must serve. The receiver must wait for the serve to come to him or her. Not so?
Well, I'm not suggesting that it's an outdated concept, but what we would take issue with is that the choice by the dominus litis of which forum to litigate in cannot be a choice that is that is not open to challenge. And if I go back to my hypothetical Northern Cape example of the litigant who gets brought to Kimberley 500 kilometers away from home, who has a defense who can't articulate, who can't advance it in the Kimberley High Court, who would be able to advance it at home. There must be a remedy for that litigant, and it can't. The answer to that litigant cannot be, well, the dominus litis has chosen Kimberley.
Well, before I ask my last question, just an observation. As a child of the Northern Cape, the furthest point is 800 kilometers from Kimberley. I know because I did the circuit courts, and that example leaves out of the reckoning the circuit courts, of course, Mr. Chaskalson. There are quite a few. There are like six circuit courts there, so the litigant could go to the circuit court, which is much closer to the town.
But Justice Majid, the argument with respect strengthens our proposition, because if the bank decides it's going to sue the litigant in Kimberley, the litigant can't be stuck in Kimberley.
Yes, no,
at the very least, the litigant ought to be able to say, take me to the circuit court.
Can I ask you, two of the grounds on which the High Court reached its decision was first the abuse of process point and then also the inherent jurisdiction point. I take it you don't rely on those two at all because you've confined your argument to mandatory jurisdiction and to access to justice, those two.
Certainly not abuse of process. I'm not suggesting that every application in the High Court is an abuse of this nature.
Because clearly that's not how abuse of process is understood in our law, in our jurisprudence.
Well, I'm not defending that aspect of the High Court judgment, but on inherent jurisdiction, I would submit that the High Court does have inherent jurisdiction to protect its own process. And it goes back to the answers to the questions that Justice Untitled was putting to me, that at the very least, a High Court that finds itself swamped in a way that is, with matters of this nature, in a way that is interfering with its ability to dispense justice, ought to be able to issue a practice directive saying, if you want to bring matters within the Magistrates Courts jurisdiction before our courts, you need to justify why we should be deciding them.
But you would accept, Mr. Shaskelson, as a general proposition that inherent jurisdiction doesn't mean that a court can clothe itself with jurisdiction that it doesn't have in terms of either the Constitution or a statute. Do you accept that?
There is no statute.
As a general proposition. Let me be more specific. Let me be more specific. When you read the Constitution, section 169 says that the High Court has the jurisdiction, excluding that of the Constitutional Court, and for the rest, it has the jurisdiction assigned to it by an Act of Parliament. Now, we know that Act of Parliament is the Superior Courts Act, and more particularly section 21 and section 27. Now, when one looks therefore for what is the jurisdiction of a High Court, you would look at in terms of the principle of subsidiarity. And also because the Constitution tells you so, you would look at the Superior Courts Act, not so?
But we're at cross purposes, Justice. 173 speaks of the inherent jurisdiction of the Constitution,
yes,
of the High Court.
Yeah, but I'm taking it further. I'm saying you cannot use inherent jurisdiction to clothe yourself with jurisdiction in terms of cases you can hear and can decline to hear based on that inherent jurisdiction. I say you must look at section 169 of the Constitution and section 21 of the Superior Courts Act, not so?
In that respect, I would respectfully disagree, Justice Majid, because 173 expressly vests the High Court with the power to protect its own process. And it's exercised that, to take an obvious example, it exercises that power when it declines to hear matters that it regards as an abusive process.
Well,
now
you said you don't
that
do,
power,
well, this is not an abusive process case. We agreed on that.
I'm illustrating that section 173 is the source of the power not to entertain abusive processes. Similarly, if it's necessary to protect the process of the High Court, to decline to entertain Magistrates Court jurisdiction matters, unless there are good grounds for doing so, that would fall within section 173. And I do want to emphasize, one gets a flavor of it from the High Court judgment. This is not a flippant concern of the Gauteng High Court. There is a very real, and it came straight through the hearing and it comes through the judgment, there is a very real consideration that vast amounts of High Court judge time are being spent dealing with default judgments that could be dealt with in the Magistrates Court. And that is not a rational use of High Court resources, and it is impairing the process of the High Court.
Yes, thank you, Mr. Chaskell. Thank you, Justice Madlanga.
Mr. Chaskelson, can I ask you this? The position you advanced, the default position, does it not attract considerable difficulty in that, one, it could lead to considerable judicial uncertainty in that the High Court would have such a wide discretion, and a discretion that would trigger questions of geography, questions of the functionality of courts, questions of the position of the individual defendant, that the default position would mean that a plaintiff who would ordinarily be entitled to approach the High Court may not be in a position to indeed investigate all those matters that would require a court to exercise its discretion properly, with the result that the effect could be inadvertently to close the door of the High Court to a plaintiff where perhaps it should not be so closed. The second difficulty is that determination when the discretion is exercised would come after considerable costs have been incurred. There would be the issue of process. There would be the question of service, and generally personal service is required, which often would take place after considerable costs, the enrollment of the matter, the waiting for a date, and then only would the court be in a position to exercise its discretion. Would that not undermine the whole notion of access to justice and sort of saving legal costs? And so from a sort of principled position and a practical position, does it not create difficulties that you say should be avoided?
Justice Collipin, practically, one would imagine that that if it does become the default position, the number of cases that are brought to depart from the default are going to be far less, so that systemically the cost issues that you speak of are going to be much less significant than the current situation where you have thousands of default judgments of magistrates court level default judgments being brought in the High Court. And the issues, one would imagine, would be relatively simple. The issues would be for the plaintiff to explain why they need to come to the magistrates court, as to the High Court as opposed to the magistrates court, would usually be, this magistrates court where I'm supposed to go to is dysfunctional. I'm not going to get justice at this magistrates court. And that would be a very simple set of allegations for the banks would know very quickly which magistrates courts are dysfunctional and which are not. It's not going to add much to the costs of this process to articulate those facts. And there would be an added benefit, which is that if the banks are forced to bring to the attention of the High Court the dysfunctional magistrates courts, well, then that would bring it to the attention of the High Courts, and then there would be more prospect of sorting out the dysfunctional magistrates courts, which is something that the judiciary really needs to do. And so in terms of access to justice more generally, we submit that there would be nothing wrong with that sort of, with a default rule. We accept that it would be better contained within a practice directive within particular divisions, where particular divisions can think about particular concerns. It may be that the particular concerns have been overloaded that animate the Gauteng court, don't animate other courts. It's not an issue in other courts. And then there are, that concern doesn't feature, and then the issue only becomes access to justice. And is it fair to take a defendant far away from their place of home to litigate a matter that could more reasonably be litigated at home? But our submission is that those issues could very easily be canvassed with a default rule that is contained in a practice directive issued division by division. The problem with the Supreme Court of Appeal judgment is that it would preclude any such exercise. It would preclude also even the case-by-case exercise of a discretion in the name of access to court where there are opposed applications and where the defendant says, I can't litigate this matter here. If you force me to litigate in Kimberley, I'm not going to be able to do so, and this judgment will be taken against me by default. That, with respect, cannot be right.
How much more time do you want, Mr. Chairperson?
Justices, I think that I have traversed more or less everything that I wanted to traverse. Can I quickly just confer with my juniors to see if there is anything else that they would like me to address specifically?
If I had known, I would have said we should take the tea adjournment, colleagues. I thought it was going to be a few minutes.
Sorry, Justice Madlanga, I apologize.
Not at all, Mr. Chairperson. Yes.
I think the only remaining issue relates to the order. And in that respect, we submit that this court ought to set aside the Supreme Court, whatever this court decides. This court should set aside the Supreme Court of Appeal order because it is framed in terms that are clearly too broad. I've addressed this issue earlier, but it appears at page 500 of the record, and what the Supreme Court of Appeal declared is that the High Court must entertain matters within its territorial jurisdiction that fall within the jurisdiction of a magistrate's court if brought before it. And our submission is that that goes far too broad, and that at the very least in cases where there is a clear evidence that the fundamental right of access to court will be violated by hearing those cases, the court should decline to do so. And so we would submit that an appropriate order would be one that declared that the High Court has a judicial discretion not to entertain matters that fall within its jurisdiction and the concurrent jurisdiction of the Magistrates Court. What the court wants to go, what the court would say beyond that is we don't have clear submissions on. It's clear that that discretion would have to be exercised on the basis of a reasonable judicial discretion. Our submission is that this is ultimately an issue which ought to be regulated with practice directions at High Court level, and that it's the courts themselves that ought to issue those directions. It's not a matter for the legislature to do, but we do want to submit strongly that the Supreme Court of Appeal order, which says that you can never refuse to entertain a matter that falls within your jurisdiction, is wrong and ought to be varied by this court. Those then are our submissions, Justices.
Thank you, Mr. Shaskowson. Let us adjourn and resume at 11:38. Court adjourn.
Court will adjourn until 11:38. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone and then rejoin with video and sound when the hearing recommences at the time of 11:38. Should you wish to exit, you may use the same link to rejoin the hearing.
Ms. Mnaweni, I'll hear from you when everybody is back.
Justices of the Constitutional Court, all counsel are online.
Thank you. Yes, Ms. Hofmeyer.
Thank you, Justice Madlanga and members of the court. Justices, I propose to divide my argument into 5 topics. The first will be to identify what this case is about. The second will involve explaining why the Constitution reserves to Parliament the task of deciding what matters will be dealt with by what courts. The third aspect I will address is what meaning should be given to may in the chapter of the Constitution dealing with the courts and the administration of justice. The fourth aspect I will address will deal with an understanding of the High Court's order and its effect. You will have seen in our heads of argument that we submit that the High Court's order, in fact, results in an assignment of matters away from the High Court. And we say that that is a task that the Constitution reserves for Parliament. And finally, in the fifth instance, I will deal with the topic of facts, what facts were and weren't before the High Court, and whether its judgment can ever be justified on the basis of a development of the common law. So if we start with the first of those topics, we submit that this case raises 2 real issues of concern and the question of the right solution for those 2 issues of concern. The first issue is whether indigent debtors are being hindered in their ability to defend cases because those cases are instituted in the High Court rather than in the Magistrates Court. And the second issue, which comes out prominently in the High Court's judgment, is the reality of overburdened court roles. It is no part of Standard Bank's argument to suggest that those are not real issues of concern. They are issues that deserve attention. They require, in the case of the indigent debtor, a proper analysis to be done for the reasons why, when there are relatively small amounts outstanding on debts with banks, people are not defending those cases. The critical causality question is, are they not defending them because there isn't a defense? Or are they not defending them because of some other issues related to the fact that the case is being brought further from them in a more intimidating environment and at greater cost? Work should be done to establish that causal link. There should also be a proper analysis of what shifting cases that can be brought in the Magistrates Courts but are brought in the High Courts will do if they are all moved to the Magistrates Courts. That is a question that the overburdening of the roles requires to be addressed. It's a matter that requires analysis to be done of the existing efficiencies and resource constraints of existing courts. So both of those issues require attention. They are matters of concern. But the question is, whose task is it to address those issues, and in what way? It is a core theme of the argument of Standard Bank before this court today, and indeed the Supreme Court of Appeal's judgment, that task to address those important concerns is a task reserved for Parliament. We say that there are 2 reasons that Parliament has been left to and should have been left to address those issues. The first is that the Constitution in fact says as much, and I will take you to that in a moment. And the second is because of an appreciation of the different institutional capacities of the courts as a branch of the state as compared with the legislature. And that institutional competence is, of course, one of the foundational aspects of the separation of powers under the Constitution. So if I may begin with the constitutional text and why I say it allocates this assignment function only to Parliament. If we start with Chapter 6 and the courts and the administration of justice under the Constitution, We know that Section 166 of the Constitution establishes the various courts within our judicial hierarchy. That includes this court, it includes the high courts, and it recognizes the magistrates' courts. Then Section 167 deals with this court, Section 168 deals with the Supreme Court of Appeal, and then pertinent for our purposes today, Section 169 deals with the high courts. It's important to emphasize all of those sections dealing with each of the individual courts uses the phrase may decide throughout. And it's a key part of the argument that I'll address to you today to understand what that means. Section 169 says, and I'm paraphrasing now, that the high courts may decide certain constitutional matters, and then, and now I'll quote, any other matter not assigned to another court by an act of parliament. We say that that constitutional text admits of no ambiguity. It is parliament, which the Constitution recognizes, has the task of assigning matters away from the high courts, because the constitutional provision recognizes the high court's jurisdiction in any other matter except those assigned. Section 170 is the section that deals with other courts. It also uses the language of may decide, but it again references Parliament's role. Section 170 deals with other courts, which include the magistrates' courts. And that section says that those courts may decide the matters allocated to them by an act of Parliament. Again, Parliament's role is undeniable. And then finally, Section 171 again reaffirms Parliament's role. It says that all courts function in terms of national legislation, the product of Parliament, and their rules and procedures must be provided for in terms of national legislation. And here again, the role of Parliament is clear. So we submit first that there can be no doubt that the role that Parliament plays is one of particular importance within the allocation and assignment of matters between the courts in the judicial hierarchy. It's quite useful to consider why it is that the constitutional drafters may have made that selection. And we submit before you today that the underlying reason is one of institutional competence. This court has repeatedly recognized that it and the courts generally are functionally ill-equipped to deal with policy-laden, polycentric decision-making. The other key limitation of the courts is that they do not control the purse strings. So they do not hold the keys, as Parliament does, to build capacity within the courts in its interactions with the executive and to ensure that they are adequately resourced. We say that those two functional limitations of the courts puts them in a particularly limited capacity to address the core issues that this case is concerned with. And it is also a feature of the way judicial decision-making is done. In the course of this morning's argument from my learned friend and the questions of the members of the court, what kept coming up is the quintessential nature of a discretion. A judicial discretion is a power exercised on a case-by-case basis. That is the nature of judicial decision-making. It is not an act of across-the-board rulemaking. Secondly, the courts are institutionally limited because they don't have a vantage point equivalent to that of Parliament. A judge sitting in an individual case required to exercise a judicial discretion does not know what the impact of moving cases from her court to another court will be on the receiving court. Judges just do not have that vantage point. It's the vantage point that Parliament has. Parliament can run the impact analyses that need to be done to understand what moving cases from one court to another will do to the administration of justice in all of those courts. If you send more cases to already suboptimally performing courts, you need to be satisfied that that is a cost that can be borne, notwithstanding the fact that it will affect the administration of justice in that receiving court. And we say that that institutional difference between Parliament and the courts is why this case is actually a case about what Parliament needs to do to address those two concerns, which are genuine concerns and which should be addressed. But instead of an approach to the statutes, which is the product of Parliament, what has happened in this case is that a device of judicial discretion has been employed to solve a problem which it is ill-equipped to solve. And I'd like to just spend a moment of that.
Before you spend that moment, Ms. Hofmeyr, your 10 minutes is up.
Thank you, Justice Madlang.
Do you think your point about the impact that, for example, moving a case from the High Court to the Magistrates Court, the impact that would have on the Magistrates Court, and the fact, as you say, that a judge doing that would not be aware of the impact or its nature? Do you think that's a strong point? I'm asking that in the context of the fact that this is a matter that ordinarily would have gone to the High Court anyway. I'm not talking about the other issues that you raise with regard to yes, but this is a matter justiciable by the Magistrates Court anyway. So had the banks or any other litigant not chosen to take them to the High Court, they would have been at the Magistrates Court anyway.
No, indeed, Justice Madlang, I take the point. If I may respond in this way, what we are looking at the moment is a High Court order that creates a new rule that will shift all cases that can be litigated in the High Court to the Magistrates Court. We say that is an assignment effectively away from the High Courts of matters that the constitutional and statutory scheme allows to go either way. One has to work with resource constraints and capacity building as against the existing statutory scheme, because the Constitution says Parliament makes these choices about what matters go to what courts and does the relevant allocation. So, Justice Madlang, the fact at the moment is a situation of concurrence. That is the decision of Parliament, and we assume that it has spent time and thought about the adequate resource allocation to accommodate that concurrence. If what now happens is a new rule is devised by courts to move a whole category of cases, I do hesitate to say this case was only ever a foreclosure case, but the breadth of the High Court's order is actually to send any matter that could ever be litigated in the Magistrates Court's monetary jurisdiction back to it. So the act of that new rule being made is one that we say does need to assess resource allocation capacity, because it has readjusted the assignment and allocation that was selected by Parliament through the Superior Courts Act and through the enactment of the Magistrates Courts Act. Justice Madlang, I said I was going to move to something. It was actually a comment that you made in the course of Mr. Chaskelson's address this morning, and it highlights the respect in which the Human Rights Commission's invocation of a discretion in this case actually does not provide the solution it's looking for. I'd like to explain what I mean by that. Justice Madlang, as you indicated in your questioning of Mr. Chaskelson, the thing about a judicial discretion is that it must be exercised on a case-by-case basis. That is its quintessential feature. And as my learned friend readily accepted to his credit, this type of case is the very type of case that can't be resolved by the exercise of a judicial discretion. The reason why is because these are undefended default judgment applications. When the facts that would be relevant to assessing whether the right of access to courts is being impacted at all by the nature of the case will not be before the courts. What will come before the courts, those courts which the Human Rights Commission wants this court to find has a discretion to decline to entertain each case, are not facts that will equip it to exercise that discretion on a case-by-case basis, because all it has before it is the original summons seeking the underlying indebtedness to be paid and the specially executable order in relation to the home. It will then know that there is no intention to defend on record, and then it will receive the default judgment application. That is not a situation in which a meaningful exercise of discretion to protect the right of access to courts can be made. That is why, and in this respect, we have some sympathy for the challenge faced by the High Court. It's why the High Court had to develop a new rule. It had to develop a new rule because by its nature, discretions can't do the work that needs to be done in order to provide the solution to the two problems that I identified at the outset. And so we submit in relation to the first two topics that I wanted to address.
Excuse me, Ms. Hofmeyer. Before you move on, you've submitted that what the applicant is asking this court to do falls within the province of Parliament. I'd like you to wrap up that point then and respond to Mr. Chaskalson's submission that there is no need to leave this process to Parliament because according to him, Chapter 8, specifically Section 1691, the use of may there gives the court a discretion. I'd like to hear what your response to that. And whilst you address it, I'd like you to address what he submitted as well, that the principle laid in Agriwire is outdated because it was a principle laid during the pre-constitutional era.
Thank you, Justice Chiefly. If I may deal with the may argument then. I first need to make clear what is not the bank's submission on this aspect, because my learned friend in characterizing our argument did so with respect incorrectly. The banks do not say that the may in Chapter 8 of the Constitution, all of those sections that say each of the courts may decide certain matters must be interpreted to be a must. That is not our argument. It has never been our argument. The may, as Justice Unterholter identified in his discussion with Mr. Chaskalson earlier, and as the Supreme Court of Appeal identified, is wording used to demarcate an empowering of the courts. It is an empowering provision, not a discretion vesting provision. Each time the Constitution says each of the courts in the hierarchy may decide something, it is empowering them to decide it. So it is not the case for the banks that our argument depends on you turning that may into a must. Our argument is that that may means they are empowered to decide matters. The question then comes, well, why do high courts and why have our courts for more than a century regarded themselves as bound to exercise their discretion, except in a few cases? And the answer to that lies not in the constitutional text, it lies in the common law that lives alongside the Constitution. The mandatory jurisdiction rule is, it's common cause between all the parties in this case, a rule of the common law. It's been developed over more than a century. It is of long vintage, but we do not say should be constitutionally suspect only for that reason. I'd like to move in answer to your question, Justice Tsiki, to the issue of the other rules in the Constitution and statutes, which our learned friends for the Human Rights Commission employ to argue against an interpretation of that may as being only empowering. You'll recall my learned friend in this argument, and you'll also find it in their heads of argument at paragraph 52.3.2. Said, but hang on, that may, he says can't mean must, but on that aspect, we agree with him. It does not mean must. But he says that may means a discretion within it because, and the examples he gives, is this court's ability to deny leave, even in cases that fall within its jurisdiction because of interests of justice, or they give in their heads of argument the example of the Supreme Court of Appeal, denying leave in circumstances where, although within its jurisdiction, there are no prospects of success. We say the reason why those discretions operate in those courts is because there are specific statutory rules on which they are founded. Justice Majid, in fact, in your questioning of Mr. Chaskelson, indicated that 167 of the Constitution, subsection 6, is a rule that explains that the Constitutional Court is a court in which applicants have to obtain leave before they access it. The important point we say of that section, and I'm reading it now, comes towards its end. It says national legislation or the rules of the Constitutional Court must allow a person, when it is in the interest of justice and with leave of the Constitutional Court, to bring a matter directly to it or to appeal. That section makes it clear. It is a statutory rule, albeit in the Constitution, that demarcates a regime of leave to access the Constitutional Court. There's a similar rule, but it's in the Superior Courts Act for the Supreme Court of Appeal. You'll find that rule in section 16(1), B, and C. Those are the sections of the Superior Courts Act that require leave to be obtained, either from the High Court against which appeal is sought, or from the Supreme Court of Appeal itself on petition, before a litigant can prosecute a case before that court. So we say the Human Rights Commission's examples of these two cases are actually examples that stand against their argument, not for it. And let me explain why. It goes back to the point about whose task this is, to provide a solution. Parliament has regulated through the Constitution at 167(6) that it is only with leave of this court that matters can come to it. And then in the Superior Courts Act, that leave is required before the Supreme Court of Appeal will entertain a case, albeit within its jurisdiction. We say it is noteworthy that there is no equivalent statutory rule created for the High Courts. There is no rule that says that you must obtain leave from the High Court before you may approach it. And the reason why, Parliament would be at liberty to pass legislation to disrupt the mandatory jurisdiction rule, which is a feature of the common law. It has not done so. It did regulate in the Superior Courts Act that you couldn't go directly to the Supreme Court of Appeal and that you would require leave of that court for doing so. We say the mere fact that it hasn't acted to circumscribe the common law mandatory jurisdiction rule by the creation of a rule requiring leave indicates that the mandatory jurisdiction rule lives alongside the Constitution. Therefore, the may in section 169 of the Constitution does not vest a discretion. It is merely, as the Supreme Court of Appeal found, a section and wording that demarcates an empowerment of the courts. You must look elsewhere to know how they are required to exercise that jurisdiction. You look to the common law and you find the mandatory jurisdiction rule there for the High Courts, and you look to the constitutional text and the Superior Courts Act to see that Parliament has weighed in and has required leave in respect of both of those courts. So we submit that the may properly interpreted in those sections of the Constitution is only denoting of an empowerment of the courts, and you will look elsewhere to determine whether the courts are obliged to exercise their jurisdiction or not. That takes me, if I may, to the fourth topic I wish to address, which is our interpretation. Oh, sorry, Justice Treaty, I forgot about AgriWire.
Yes.
Yes, so you're coming in on AgriWire.
Just wanted to remind you.
Thank you so much. If I may deal with AgriWire. Now, the first thing about AgriWire is it is a post-constitutional decision. It is a decision of 2013. And it's just useful to remind ourselves about what happened in AgriWire. AgriWire was a case dealing with the relationship between the high courts and the competition authorities. It was a case in which a matter which had been referred to the competition tribunal was then sought to be reviewed in the High Court. And there was an argument presented to the court that the Competition Act had excluded the High Court's jurisdiction over these matters. The courts determined that that was not so, that the statute could not be read in that way. But then the Commission argued that even if the High Court's jurisdiction had not been excluded by the Act, the High Court should still exercise a discretion to defer to the institutional competencies of the competition authorities and decline to exercise jurisdiction in a given case, decline to hear the case, albeit within its jurisdiction. And on that crisp point, the Supreme Court of Appeal held that the courts do not have that discretion. They do not have it because, and referencing Bester, of the mandatory jurisdiction rule. Now, I do want to be clear, my learned friend is absolutely correct that AgriWire did not consider the compatibility of the mandatory jurisdiction rule with the constitutional right of access to courts. I can't say before you today that faced with that contestation, the Supreme Court of Appeal upheld the mandatory jurisdiction rule. That just was not ventilated before it. So Justice Cheeky, the highest we can go is to say it is post-constitutional confirmation of the mandatory jurisdiction rule. It arose in a case where the court was invited to decline to hear a matter, albeit that it had jurisdiction, and the Supreme Court of Appeal held that it was not to do so, that it did not have a discretion. It is a separate matter, though, what the interface between the right of access to courts is and the position of courts in the face of the mandatory jurisdiction rule. But we say sorry, Justice Tiki, are you wishing to come in again? Thank you.
Yes, no. I just wanted to say that what attracted me in AgriWire was the finding by the court in paragraph 19, where it said that save in admiralty matters, our law does not recognize the doctrine of forum non-convenience, and our courts are not entitled to decline to hear cases properly brought before them in the exercise of their jurisdiction.
Indeed, and we say that that is an articulation of the mandatory jurisdiction rule, which we say has a role to play within the constitutional scheme. You will have seen our submissions about how it can in fact enhance judicial independence rather than detract from it. But it is also founded on the Dominus Litis point that was addressed with Mr. Chaskelson. The allusions to sport are useful in this terrain. Who starts the case? Well, it is the first litigant, the Dominus Litis. But I would like to be clear on that. Apologies, Justice Theron.
Yes, perhaps before you move, and of course, subject to Justice Chitli's questions being complete for now, before you move to Dominus Litis, you were addressing us, and some of your discussion with Justice Chitli revolved around the mandatory jurisdiction principle. Can I just understand what the position of the respondent that you represent is in relation to it was argued by Mr. Chaskelson that the mandatory jurisdiction principle must yield to the Constitution. I know you started addressing that, but I would just like, in a nutshell, what the bank's position is.
Just to run, the mandatory jurisdiction rule, as I've said, is a feature of the common law that lives alongside the Constitution. The first point of our argument is that the Human Rights Commission is wrong when it says that the use of the word may in those various sections of Chapter 8 has done away with the mandatory jurisdiction rule. That's the force of their primary argument. They say that by using the word may, the Constitution has turned an obligatory exercise of discretion into a discretionary one. Sorry, an obligatory exercise of a jurisdiction into a discretionary one. We say, for the reasons I've given, that is not the correct interpretation of the word may. May does no more than demarcate the matters which each court is empowered to hear. So that is our primary submission in response to the Human Rights Commission's analysis of the interplay between the Constitution and the mandatory jurisdiction rule. But Justice Theron, there's another aspect of your question. It's this concern around its exercise and the right of access to courts and how one battles with that, the problem that interplay creates. We say, and it's the reason I spent some time at the beginning of my submissions asking who is required to provide the solution to this problem. It is our submission that the courts are functionally ill-equipped to provide the solution to that interplay. The reason why is because they can't supplant the role that the Constitution gave to Parliament to do. Parliament is functionally equipped to determine what matters should be decided by what courts, and having made those decisions, ensure that they are properly resourced to do so. An individual judge sitting in an individual case is not in a position to know the impact of refusing to exercise jurisdiction in a given case. Remember, this case is about access to courts. What the Human Rights Commission invites judges to do is to exercise a discretion in a given case on an assumption that it would be better for the defendant to be in a magistrate's court than in the High Court. It will be required to do that without any factual basis for it, for the reasons that I've already traversed, and which we say with respect were borne out by Justice Madlanga's questions. Those facts just don't come before the courts in default judgment applications. But more than that, the mere act of moving a substantial number of cases away from the High Courts to the Magistrates Courts can have an impact on access to courts within those courts. It is common cause between the parties that the elements of that right include things like how efficiently and with what delay justice can be attained in a case. Moving a whole set of cases from one court in a system to another will have an impact on the receiving court. And we say because of the very nature of those questions being polycentric, being non-binary, they are not the questions that can be answered by courts exercising an individual discretion in a given case. Justices, I wanted to then move to the penultimate aspect of my argument, which is the question of the proper interpretation of the High Court's judgment.
Ms. Hofmeyr, I'm sorry to detain you in moving on, but can I just ask you a follow-up question from the answer that you've just given? It may very well be that a rule-based answer can't be effected by discretion, but in unusual circumstances where there are facts that might entail an infringement of a fundamental right, is there anything in principle that would say, well, a High Court can't in those circumstances decline jurisdiction?
Certainly not.
In other words, isn't Agri-Wire too categoric on the basis that if perhaps in the example Mr. Chaskelson gave, there are facts before the court that would suggest a real hardship would result in a defendant not being able to present their case, isn't that an instance in which some species of discretion can be exercised on perhaps a forum non-conveniens basis or some other doctrine? But in any event, that it's agri-wire is too categoric.
Indeed, Justice Untitled. My next argument was going to require us to read the orders of judgments subject to their reasoning. I think the fairer reading of that statement in paragraph 19 of the agri-wire judgment is that what was suggested to be a motivating factor for a declining of jurisdiction in that case was a deference to another body, the competition authorities. That was not, as the Supreme Court of Appeal found, a basis upon which there could be an exercise of discretion to deny to hear a case which fell within the jurisdiction of the High Court. It is not part of our argument to suggest that in a specific case where the facts cried out for a result that involved an exercise of discretion, it would never be available to the courts. And the reason I say that with relative confidence, and it's a point that my learned friend has already traversed, the mandatory jurisdiction rule is not a rule that doesn't admit of an already existing exception. It admits of the exception for abuse of process.
Yes.
It admits of the exception in the case referenced in their heads of argument, the custody case, where a foreign court was determined to be better placed. So it's not part of our argument to say there's never a case where you might exercise a discretion. What we say is that the default rule of the common law is that courts exercise the discretion, the jurisdictions that they have, that the rule can't be reversed, which we say is the effect of the High Court's order, that you can't come to us, that you won't come to us if the matter, and we will decline hearing your case if the matter could be litigated in a different court.
Yes,
we say that's a reversal, and that is a reversal that is not supported by either the constitutional text, nor is it supported by the order given by the High Court, because the High Court grappled with this very difficulty. The problem is the nature of discretion requiring a case-by-case analysis.
Sorry,
Justice
with the leave of yeah. I seem to appreciate and understand, having been at the Johannesburg and Pretoria High Court, the frustrations that propelled the full bench to this judgment. And when I read paragraph 1 of the order, it seems to suggest that if a party wants to approach the High Court, he must ask for leave. The High Court seemed to be saying in the judgment, the full court, rather, that we are overloaded. So much work when there's another forum where this case can be litigated. But at the same time, it says, come to us if you want to litigate and ask for leave. If it gets flooded with applications for leave, what is it going to do? Because that's what it says here.
Indeed. Well, Justice Matoko, that actually does lead me to the next part of my argument, which is that we say when that paragraph 1 of the High Court's order is actually read together with its reasons, the effect of that order is not to invite applications for leave. The effect of that order is to assign matters to the Magistrates Courts. And we make that submission because on no less than 5 occasions in the High Court's judgment, and if I can just give you the references, Justices, you'll find these findings about abuse of process at page 406, paragraph 52 of the judgment, at page 418, paragraph 76, at page 419, paragraph 77, then again at paragraph 78 on that page, and finally at page 420, paragraph 81. On no less than 5 occasions, the full court of the Gauteng High Court found that the mere fact, apologies.
The last one, the last reference.
The last one was page 420, paragraph 81. In all of those instances in the judgment, the full court found that the mere fact that a litigant chooses to litigate in the High Court rather than the Magistrates Court, when either is available to them, is an abuse of process. It made that finding, notwithstanding the extensive evidence placed before it of the banks, seeking to explain why that choice was made, why that choice, in fact, was based on issues of efficiency, cost saving, effectiveness of judgments. And it, despite that evidence, concluded that the mere act of making that choice was an abuse of process. So Justice Matopo, we say that the proper interpretation of that order is one that will not admit of any application for leave being dealt with or meaningfully being capable of being brought to the High Courts, because it has already been determined that that mere choice is an abuse of process. We therefore say that the High Court's order amounts to an assignment of matters that could be litigated in the High Courts to the Magistrates Courts. And my argument then loops back to where it began. We say that that is a task that the Constitution reserves for Parliament. Can I just say one? Oh, sorry,
Ms.
yes.
Sorry, Ms. Hoffmeyer, can I just go back to your acceptance that there could be individual cases where the court can exercise a discretion? You caution that that shouldn't be the default position, but that in individual cases that can and it's permissible and perhaps desirable for the court to be able to do so. The two questions I have is that, given that we largely accept that these cases come to court where a defendant is underrepresented and a plaintiff may not have been in a position to place information before the court. So the question is, can the court exercise such a discretion mero moto without being asked to do so? And if it is able to exercise it mero moto, on what basis and on what facts does it do so? And then the second question is, on the basis of your acceptance of such a discretion, would you say that the order of the SCA really closes the door to the exercise of such a discretion, to the extent that it's quite clear that it says it's obligatory for the High Court to deal with those matters? And in that case, would this court be entitled to revisit that order to that extent?
Thank you, Justice Collipin. The answer to the question of whether a court can do it mero motu is, in our submission, that it cannot. And it cannot simply because it will not have the necessary facts before it. Those exercises.
So what would be the benefit of having the discretion? Would it simply be really a matter, an academic issue then?
Well, I think the postulate from Justice Unterhalter was a case where those facts were some way or another brought before the court. Where there is a factual basis, it is no part of our argument to say that a court would doggedly insist that it must hear a case, notwithstanding evidence before it that it would implicate rights. That's the essence of our submission. I do want to just make a related point, because I've forgotten to go back to the dominus litis aspect, and it's related to this before Justice Collip and I go to your second question. There's been some suspicion, I think, cast by the High Court's order on the dominus litis role in litigation. It's important to indicate that that role of the dominant litigant in choosing the court in which to bring a matter is not an inviolate rule. There are already mechanisms for matters to move to other courts. The Supreme Court of Appeals judgment traverses them. There's a uniform rule 3922, which, pursuant to consent between the parties, will enable matters to move. The plaintiff selects, the parties engage, and if they agree, matters will move. It's important to emphasize on that score that Standard Bank's own evidence before the High Court was that when it is approached by a debtor who indicates a preference for another court, the Magistrates Court, in which to litigate the matter, the Standard Bank does, in appropriate cases, consent to that move. So there is already a mechanism. There is also the section of the Superior Courts Act, which allows, on application, matters to move between the high courts. So it's just important that I indicate an acceptance that a plaintiff chooses which court is not a choice for all time. There are rules that have already been designed to accommodate a divergence from that position. But Justice Collipin, your second question was, does the SCA's order go too far? Well, Justice Collipin, if we just look at it for a moment, we'll find it in the record at page 499. Paragraph 1 of that order says that the High Court must entertain matters within its territorial jurisdiction that fall within the jurisdiction of a magistrate's court if brought before it because it has concurrent jurisdiction with the magistrate's court. That statement is, with respect, already inconsistent with the mandatory jurisdiction rules recognized exception for abuse of process cases. That statement cannot possibly mean that even in a case of abuse of process, a court would be bound to entertain the matter. So we submit that the proper interpretation of these paragraphs of the order is to read it as responsive to the very questions that came before the court, the very issues before it. Can the mere fact that a matter could be litigated in the magistrate's court and the High Court be a reason for the High Court not to exercise its jurisdiction? The answer to that is no, and it's reflected in the statement that appears in paragraph 1 of the order. That paragraph of the order is responsive to the key question before the court, which
Ms.
is where
directly on that point, Ms. Hoffmeyer.
Yes, right.
Oh, thank you, Justice Madlanga. How could the order be amended so that on its face, the meaning that you have now articulated in response to the question raised appears from the order?
Justice Turan, I wonder if I could enlist the assistance of my team. I'm not sure that I'd want to work with crafting an order just off the bat in submissions. If we could give it a bit of thought, I'd appreciate that. Thank you. Then I'd like to move, if I may, to the last topic.
We are 2 minutes beyond the end point, Ms. Hoffmeyer. How much more time do you want?
I suspect I can do it in 5 minutes.
5 minutes, that's to 12:30. Please continue.
Thank you so much. I said in the last instance, I propose to deal with the question of facts. Justices, you will have seen in our heads of argument that we spend a great deal of time traversing what facts were before the court and what facts were not before the court. I'm not going to go over those submissions again. I'd rather like to pick up on 2 points that my learned friend, Mr. Chaskelson, made in his oral submissions this morning. He said first that the court could draw from the fact that 7 of the 11 cases that were originally referred to the full court were subsequently withdrawn. You could draw the conclusion that those cases were cases where the defendants had an answer or a defense which would stop their home being sold in execution. He employs that argument because he seeks to use it as an indicator that but for this referral to the full court by the judge president, these cases would have continued to be default judgment applications taken without further recourse. We submit that that conclusion is not supported by the evidence before the court. And the reason for that is that the banks went into extensive detail, Standard Bank in particular, to traverse before the courts the engagements that occur between the banks and debtors before they even issue summons. The Standard Bank facts show that those engagements took between 4 and 8 years from the first instance of non-payment. The second point that was made clear is that in each of the Standard Bank cases, the reason why those matters were withdrawn was because arrangements were made for repayment. You will find those facts, if I can just give you the reference, page 97 from paragraph 35. So it is not so we submit on the evidence before this court, and that was before the High Court, that you can deduce that 7 of the 11 cases would have proceeded axiomatically to default judgment if it hadn't been for some opportunity presented by the judge president's directive. The evidence of the banks is they continue to engage before, for many years, and even thereafter with debtors. And when arrangements can be made, matters are withdrawn. That's the evidence before the court. The second point that I'd like to make in response is actually a point that I've indicated in answer to the Dominus Litis point. There are mechanisms in terms of which matters can be moved from the High Court, even when that court is chosen by the banks. That is pursuant to the mechanism of consent, and Standard Bank's evidence, which you'll find at page 84, paragraph 28.2, is that it does consent. When a debtor raises with it that a matter could be better defended by that debtor in the Magistrates Court, Standard Bank's evidence is in appropriate cases, it will consent to move the matter to that court. Justice Madlanga, those are the submissions of the Standard Bank of South Africa.
Justice Madlanga, can I raise one aspect, please? Ms. Hofmeyer, just one aspect. Towards the end of his address, Mr. Chaskelson seemed to concede that it would be better, or to suggest that, not concede, that it would be better for a practice directive to be employed rather than the declarator that the full court has issued. It doesn't seem to me to be, it struck me afterwards, doesn't seem to me to solve the problem, because it's 6 of one and half a dozen of the other. As I understand it, judges president have a delegated authority from the Chief Justice to issue practice directives, and it would bind the whole division. Indeed. As the declarator does at the moment.
Indeed, Justice Majid, and I'm indebted for the question because it's actually an aspect I did want to traverse and had overlooked. We submit the practice direction is no solution for 2 reasons. With respect, the first is the one you've given, that it doesn't admit of then a discretion on an individual case basis if it is going to operate as a general rule. But the second problem is that if it is operating as a general rule, then it is an act of assignment. And practice directives cannot assign matters away from the courts. The only body empowered to do that under the Constitution is Parliament.
Yes, thank you. Thank you, Justice Madlanga.
Thank you, Justice
Thank you, my brother. Thank you, Ms. Hofmeyer. Yes, Mr. Cockrell.
Thank you. Thank you, Justice Madlanga. Members of the court, I'd like to address 4 issues today. I'd like to begin by dealing with what is the issue before this court. In other words, what is the issue this court should be grappling with? I then want to deal with whether the Constitution has changed the pre-constitutional principle that a court must exercise jurisdiction if it has it. The third issue I want to address involves the applicant's criticisms of the SCA judgment. And then the fourth issue I want to address is what should this court do? What order should it give if it is persuaded by our learned friend for the applicant that the SCA was wrong? So those are the 4 issues I want to address. And let me start with this one, which is what is the issue before this court? Now, it may sound like a curious question to phrase, but with respect, it's critical because everyone on this court will know before you answer a question, you have to understand what the question is. And listening to our learned friend this morning and listening to the extremely helpful debates between our learned friend and the court, it became apparent, at least to me, that different participants in the litigation as it has progressed and different parties have understood the issue in different ways. So let me take the example given by my learned friend, Mr. Chaskelson. I'm going to take his Northern Cape example, which I understand is this. There's a defendant living 500 kilometers from the Kimberley High Court. She or he is sued by a bank in order to get, in effect, foreclosure on the home. And the litigant, the defendant, travels to the High Court and says, I want to defend this action. I can do so in the Magistrates Court, that is 2 kilometers from our home, but I can't do that in the High Court. Now, just taking that as a hypothetical set of facts, with respect, it seems to us there are at least 3 different questions that may be asked, and let me give them to you. The first formulation would be this: may the High Court decline to exercise jurisdiction on those facts on the basis that the Magistrates Court has concurrent jurisdiction. That's the first formulation. May the High Court decline to hear the matter. Second formulation of the question may be, may the High Court transfer the matter to the Magistrates Court. Say it again. May the High Court transfer the matter to the Magistrates Court. And a third formulation of the question would be this: may the High Court create a default rule that prevents litigants in all cases from suing out of the High Court if a Magistrates Court has concurrent jurisdiction. I'll say it again. May the High Court create a default rule that prevents all litigants from suing out of the High Court if the Mag Court has concurrent jurisdiction. Now, Justice Matlanga, members of the court, I draw those distinctions because, with respect, those are very, very different questions. Let me start with this. The first formulation of the question is not the same as the second formulation of the question. If a High Court declines to exercise jurisdiction, it doesn't hear the matter at all. As Justice Theron, with respect, correctly pointed out to our learned friend, Mr. Chaskelson, if a High Court transfers a matter to the Magistrates Court, it is exercising jurisdiction. It's exercising jurisdiction and then transferring it. So the first question and the second question are not the same. And the third question is different to both of the earlier formulations, because it would at least be conceivable that this court may decide the answer to the first question is yes, answer to the second question is yes, but nevertheless, a High Court doesn't have the competence to create a procedural rule which bars all litigants in future from ever using the High Court if the Mag Court has concurrent jurisdiction. And indeed, I understood my learned friend to concede that. I'll come back to it, at least in relation to the High Court. He suggested that a practice directive may be more appropriate. He seemed to concede that the High Court in a judgment wouldn't have the power to create that rule. So those are the formulations of the questions, and they are very different with respect. Now, if you cast your eye back over the litigation, what becomes apparent is that different courts have understood the question differently. If one thinks back to paragraph 1 of the order of the full court, that, of course, was dealing with the third formulation. What the full court did in its first paragraph was, in effect, to create a procedural rule, a default rule, saying, whoever you are, you will not sue out of this court if the Mag Court has concurrent jurisdiction. Now, the full court then went on in paragraph 2 to deal with what I'm calling the second question. It dealt with transfer. It's a somewhat curious process of reasoning because, of course, if you can't sue out of the High Court at all, the High Court would never have to exercise the power of transfer. But nevertheless, the full court dealt with that in paragraph 2 of its order. And if you now go to the order of the SCA, it, of course, was dealing with the first formulation of the question. So from the SCA's perspective, what it was asked to deal with is the first question, not the second question, and not the third question. Now, Justice Matlanga, members of the court, I do that exercise because, with respect, if one now looks at the Human Rights Commission's case, the question would be, how does the Human Rights Commission understand the question before this court? Is it the first formulation? Is it the second formulation? Is it the third formulation? And you'll know from our heads of argument, we were unsure, quite frankly, what the human rights understanding of the case was, because what they say in their heads on more than one occasion is a High Court in appropriate cases should decline to exercise jurisdiction and should transfer the matter to the Magistrates Court. But you've already heard my submission on that. If the High Court transfers the matter, it is exercising jurisdiction. And so we listened with interest today to my learned friend, Mr. Chaskelson's address. And as we now understand the position, he said, in an appropriate case, What the High Court should do is decline to exercise jurisdiction, to strike the matter from its role, was the phrase he used. And that ambivalence in the Human Rights Commission's attitude is then demonstrated when this court asks itself, is the Human Rights Commission, the applicant before you today for leave to appeal, is it defending the order of the full court? And as I understand it now, the answer is no. Because you didn't hear a word from my learned friend, Mr. Chaskelson, on defending the order. On the contrary, he very fairly conceded that if that's the way to go, that would be something for a judicial directive, not for a judgment of a court. Now, Justice Madlanga, members of the court, I do that exercise because what I'm going to address today is this. I'm going to address what I'm calling the first formulation of the question, which is the way the SCA understood the issue. The question I want to deal with is, was the SCA right to say that where a court is vested with jurisdiction, it's obliged to exercise that jurisdiction? I'm going to answer that in the fourth part of my address when I come to what remedy this court should give if it's persuaded that the SCA was wrong. I'll then deal with the second and the third formulation, because with respect, those formulations of the question would become relevant if you were to form the view that the SCA was wrong. But that's the background. And Justice Madlanga, I'm going to move on to the second topic of my address, but I'm happy to waive the rest of my 10-minute period because before I move on, it may well be that there are questions arising from the three formulations of the question that I've suggested are appropriate for this court.
Please continue.
Mr. Cockrell, I just want clarity. I noticed when you read the order of the High Court, you left out the part where it said, unless the High Court has granted leave to hear the matter in the High Court.
Yes, yes.
What
yes,
is
I left
the
it out. Yes, I left it out for a reason, and I'll address you on this in due course. But here we make common course with Standard Bank. The full court ruled it was an abusive process to use the High Court where the Mag Court has concurrent jurisdiction. Once that's the case, it's difficult to see how the High Court could ever give you leave, you being the plaintiff. So in other words, if you interpret the order literally, you're entirely correct, Justice Badanta. It means my client, Nedbank, can go before a High Court and say, give me leave to sue out of the High Court, not the Mag Court. But with respect, the answer should be, the full court has ruled it's always an abusive process to use the High Court. So there's an internal contradiction in the reasoning of the full court, and that's why I left out those words, but you're entirely correct. They are there as a matter of form, Justice Madlanga.
Now, if we have to look at the order, because that's what we normally look at, what should we do with that order? Because if it says leave would be granted.
Just the submission I'm going to make in due course is, even if you are persuaded that the SCA was wrong, the one order this court should not reinstate is paragraph 1 of the order of the full court. And I'm going to make that submission because nobody before you is defending that order. Even the Human Rights Commission is no longer defending that order. So with respect, even if you were persuaded by our learned friend that the SCA was wrong, I believe it to be common cause before you that paragraph 1 of the full court order should not be reinstated because nobody, with respect, thinks it's correct. Now, what you should do if you don't want to reinstate paragraph 1 is an issue I'll address when I come to the fourth part of my address.
Okay, thank you.
Mr. Cockrell, I wonder whether I could ask you this. In the catalogue of questions that you have given us, if there is a true case of an abusive process, which I don't think anyone contends for in respect of what happened in this case, but a true case of abuse, is that an exercise of jurisdiction?
Yes, yes, with respect it is. So the court doesn't strike the matter from its role. The court hears the matter and the court says the process has been abused, and therefore I dismiss the application.
Yes.
So
there's a distinction then between declining jurisdiction to say I can't hear the matter in any form and exercising it in a way which leads to a result that you say there's been an abuse, I won't hear the case for that reason.
Yeah.
Where would you, though, then situate a a contention such as forum non-conveniens. In other words, the kind of case I was putting to Ms. Hofmeyr, where a litigant comes along and says, I'm going to be denied a right to put my case to a court because I can't get to Kimberley.
Yeah.
Is that, in your typology, an exercise of jurisdiction in respect of an infringement of rights case?
No, with respect, in our submission, that would be the court declining to exercise jurisdiction to say, I won't hear the case. And so here we have a different, our position is different to that of Standard Bank. In our respectful submission, the court has no power to do that. The appropriate remedy in Nedbank's submission would be then to transfer the matter to the Magistrates Court, which is 2 kilometers away from the home. Because you'll know from the affidavit, the position of Nedbank is different to that of Standard Bank and FNB in this respect, because Nedbank accepts that it would be competent to transfer a matter outside of agreement within the meaning of Rule 3922.
Yes. So I mean, in essence, by reason of the different remedy, which is transfer rather than an outright declining of jurisdiction, that you would class as another case of exercising jurisdiction.
Absolutely. The court assumes jurisdiction and the court transfers it, as opposed to saying, I won't hear you at all. If I can put it bluntly, get out of my court, you're in the wrong forum. That's what a court doesn't do when it transfers it.
Yes, and just one last example. Sometimes there are courts, not often in our jurisdiction, which exercise comity. They say there's another court which is better connected or better purposed to deal with the case. So I rule that the matter should go there. Yeah. That presumably would be another instance of exercise rather than declining.
Yes. Yes, with respect, Justice Untitled, that's correct. And at least from our perspective, that's how we understand Strang. That's a judgment Melinda and Mr. Chaskelson relies on. Strang was a judgment of the SCA, which created new rules for suing a peregrinous defendant, but then said it may be, in some cases, it's more convenient for the matter to be heard by some other foreign court. And so we would understand that not as a declining to exercise jurisdiction, but as assuming jurisdiction and then saying the matter should be heard by another court for reasons of comity, as you point out, Justice Untitled.
Yes, thank you very much.
But Justice Untitled, I think you call them a catalogue of questions, my typology of questions. It's not an academic exercise, because I'm going to indicate in due course when we come to the relief that this court should give, if it's persuaded that the SCA was wrong, with respect, the catalogue of questions does become important.
Yes.
Now, may I then proceed to the second part of my address, which is this. The SCA understood the question to be, may the High Court decline to exercise jurisdiction, refuse to hear the matter, to put it bluntly, because a magistrate's court has concurrent jurisdiction. And let me deal with that, if I may, in this, the second part of my address. And let me start here, Justice Madlanga, members of the court. In the pre-constitutional era, there were 3 principles that one would have read in any textbook and that would have been taught to any student in a civil procedure lecture at law class. And the principles were these. Number 1, the plaintiff elects which court to use if 2 courts have concurrent jurisdiction. And our courts held for more than a century that the High Court could not decline to exercise jurisdiction merely because the Magistrates Court also shares concurrent jurisdiction. Not going to burden you with the authorities, they're in the heads, it's best in all of those cases. That was the first rule. Second rule, there's an exception to that first rule, subject to Justice Untild's question to me about whether it's exercising jurisdiction or not exercising jurisdiction. But the rule was, if the process before the court was being abused, a High Court may dismiss the application or refuse to hear it on the basis that it's an abuse to use the High Court rather than the Magistrates Court. But that would be a fact-specific inquiry. It would depend on the facts of a particular case. So that was the second rule. And the third rule, well established, was If a litigant chooses to use the High Court when he or she or it could have used the Magistrates Court, the High Court may award costs only on the Magistrates Court scale, not on the High Court scale, even if the plaintiff or the applicant were to be successful. Now, those are the rules that one would have read in any standard textbook on the subject. And so the question for this court is this: we accept that those rules are not immutable. It's certainly possible that the Constitution could have changed those rules. But the question for the full court and for our learned friends, for the applicant and for this court is, has the Constitution changed those three rules? And in order to give an affirmative answer to that question, one would, with respect, either have to go to a section of the Constitution which changes the position, or one would have to say, well, there's a principle of the Constitution, and that principle, even though not grounded in a particular section, has changed the old law. Or number three, a court would have to say, well, those three principles were part of the common law, and the common law has now changed in the light of constitutional values. And again, I do that exercise because we accept the Constitution may have changed the old position, but one would at least have to engage in the discipline of pointing out that's the provision of the Constitution that does the work, or this is the constitutional principle that does the work. Now, with respect, Justice Malanga, justices of the court, when one reads the full court judgment, one sees the full court grappling with what is the provision in the Constitution that has changed the old law. And one sees that also in the submissions of our learned friend for the Human Rights Commission. They also struggle with this issue. What is the provision in the Constitution that has changed that? And let me put on one side for the moment what our learned friends say. If one goes to the judgment of the full court, it seems to us that the full court came up with the following possibilities, things that may have changed the law. Number one, the full court said, well, what about Section 34 of the Constitution? That's the right of access to court. And with respect, we would submit the full court was right in this regard to say what Section 34 does is it guarantees someone a right of access to court, but it doesn't guarantee anyone a right of access to a particular court. It says the doors of the court can't be closed to you, but it doesn't guarantee you a right to get through the doors of this particular court. Kimberley Court, for example, as opposed to the Cape High Court.
Well, Mr. Cockrell, let me stop you there. You place heavy reliance on a sentence in Mukadam's case. But I wonder whether it can bear the weight that you give it, because I think it was simply saying it's not open always to choose which court you go to. There will be rules that determine questions of that kind, including the statutes that prevail in our law. But was it really covering the separate question, which is that when you go as a defendant to a court, you may still be able to persuade that court that some aspect of access to justice is being imperiled. For example, in the instance that Mr. Chaskelson raised. Okay. Yes. So it's not that you must just go to court and accept that you're there, come what may. There may be circumstances that require consideration as to whether access is really adequately being afforded you.
Yes. Justice Untitled, we have no difficulty with that. Mukadam didn't purport to say that, but we accept it may be open to that reading. So when you ask me whether the dictum in Mukadam can bear the weight of that submission, we accept perhaps it's too much. But the submission I do make is this. If one asks, what did the full court do? The full court tried to hook onto your suggested extension of Mukadam, a principle that led to a rule saying you can never use this court if the Maj Court has concurrent jurisdiction. And we would say, even if Mukadam were to be qualified in that respect, and we would understand the qualification, it could never bear the weight of what the full court did in paragraph 1 of its order, because by definition, Justice Untitled, one would have to say, Here's my learned friend's example. The person in the Kimberley High Court saying, I would oppose in the Maj Court up the road, but I can't travel to the High Court. But that, on your hypothesis to me, may justify a particular decision in that case, but it could never justify the blanket rule which says nobody can use the High Court if the Maj Court has concurrent jurisdiction.
Yes, thank you.
So that's the first possibility, section 34. A second possibility would be section 173 of the Constitution. Well, with respect, we would submit that's a non-starter because section 173 is, if you like, a constitutional codification of inherent jurisdiction, and it's difficult to understand why section 173 on its own would have altered the pre-constitutional position. So that leaves us then with the principle that powered the full court judgment. The full court relied on this principle of access to justice. Now, that is not a principle one will find in a particular provision of the Constitution. It is a principle extracted from the interstices of the Constitution. We have no difficulty with that. Of course, it's sometimes legitimate to do that. But with respect, we would submit that when one looks at how that principle of access to justice was used by the full court, with respect, there was simply no factual basis for what the full court did. The full court held, and this loops back to my earlier engagement with Justice Madlankla, the full court held that it's always an abusive process. It is always a denial of access to justice. In every case, if a bank or any other litigant uses the High Court when it could have used the Magistrates Court. And with respect, there is simply nothing on the papers to show that that is the case. Perhaps there would be instances where that is the case, but it simply doesn't justify the rule that the High Court created, which is that nobody would be able to use the High Court for issuing summons if the Magistrates Court has concurrent jurisdiction. And so where that goes, subject to section 169, which I'm going to come to, that's the argument of my learned friend, where that goes in our respectful submission is the SCA was correct. The SCA traced the earlier development of the law through over a century of development. It asked itself, has the Constitution changed those principles? And it said there was no constitutional basis for finding that those principles had changed. And in our respectful submission, that was correct. Now that brings me then to the third part of my address, which is the criticisms of the SCA judgment by our learned friends for the applicants, for the Human Rights Commission. And I want to deal with two issues here, if I may. The first is their reliance on section 169 of the Constitution, 1691, and the second is the facts on which they rely. Let me start with section 169, because with respect to them, this is the most innovative part of their argument. What our learned friends say is the magic is done by section 1691 because it says the High Court of South Africa may decide, and there follows a list of certain matters. And so our learned friends say, well, that is what has changed the position that existed before the Constitution, because the may is giving the courts a discretion without imposing an obligation on them. Justice Madanga, members of the court, I'm not going to rehearse the debate that you've had with both of my learned friends who have argued before me. Justice Unterhalter, with respect, put the proposition to my learned friend, Mr. Chastelson, that sometimes the word may is conferring a power, but not talking to whether the power must or must not be exercised. We would, with respect, agree with that. The submission I want to make is a slightly different one because it hasn't been covered yet. It's this. Assume, purely for the sake of argument, that my learned friend is right, Mr. Chastelson. Assume that the may is there conferring a discretion on the court. It's our submission that even if one makes that assumption just for the sake of argument, it still doesn't get the applicant over the line. It doesn't get them where they want to be. And the reason for that is the principle of subsidiarity that Justice I believe it was Justice Collipin, but I may be doing a disservice to Justice Majid. Certainly, it's the principle of subsidiarity that was referred to in the course of a debate with my learned friend, and we refer to it in our heads of argument. But let me just give a simple example, if I may, to indicate why it's relevant. I've just checked my notes. It was Justice Majid who raised the point with my learned friend. I do apologize. I'm Justice Collipin. The principle of subsidiarity is relevant for this reason. I want you just to assume a hypothetical example. I'm talking to you from Cape Town at the moment. Let's assume I have a client in Cape Town who is domiciled in Cape Town, and my client wishes to sue a defendant, assume it's R1 million over the jurisdiction of the Mag Court, and assume the defendant is domiciled, is resident, and does business in Johannesburg, and assume that the cause of action arose in Johannesburg. Now, I will tell my client section 21(1) of the Superior Courts Act means you cannot sue out of the Cape High Court because jurisdiction over the person in this case vests in the Gauteng High Court. But if my client were to say triumphantly, well, I'd rather use the Cape High Court, and if anyone challenges jurisdiction, I'll rely on section 1691, which says the High Court may decide any matter, and that includes this matter. I will say that the High Court has jurisdiction because of section 1691. Now, with respect, that would be a poor argument in our submission. And it's a poor argument because when you ask, does a particular division of the High Court have jurisdiction over this particular defendant? The answer is given by the Superior Courts Act, not by section 1691 of the Constitution. And the principle of subsidiarity means you can't cut through all of that lower level legislation, the Superior Courts Act in this case. You can't cut through it and run an argument based on the higher level principle, section 1691. And in our respectful submission, that is why the submission of the Human Rights Commission is wrong. Although they seek to make section 1691 do a great deal of work, even if the may bears the meaning they suggest it means, and I make that assumption purely for the sake of argument, it would still not get them over the line. Because section 1691 is not dealing with the jurisdiction of a particular high court. It's dealing with the jurisdiction of the High Court as a globular body. If you ask the question, does the High Court have jurisdiction over a person? The answer will be, but the question is meaningless. The only meaningful question is, does this particular division of the High Court, Gauteng, Cape, Kimberley, whatever it is, does it have jurisdiction over a particular person? And the answer to that question is not contained in section 169 of the Constitution. It's contained in the Superior Courts Act. And that's the very thing envisaged by the constitutional scheme, because the only time you'll see jurisdiction mentioned in section 169 is in 169 2b, which says the High Court consists of divisions and an Act of Parliament must provide for the jurisdiction of those divisions. So with respect for all of those reasons, we would respectfully submit that section 169 of the Constitution does not assist our learned friends in the argument that they seek to address. I need to also make a brief submission to you regarding the facts that are relied on by the Human Rights Commission. And this is a debate, Justice Madlanga, you raised this with my learned friend, Mr. Chaskelson. What about the absence of any facts? My learned friend, Mr. Chaskelson, very fairly, may I say, accepted. He couldn't say that in every case where a defendant is hauled before the High Court, he or she would have opposed had it been in the Magistrates Court. He very fairly said he couldn't say that. But he did make the submission that there will be at least some cases, and possibly even many cases, where that is the case. Well, here's the difficulty, Justice Madlanga. The reason why we don't have any facts is because the Human Rights Commission didn't give us those facts, even though they said they were going to investigate the matter. And I am going to ask you, please, if you have the record available, to go to this. It's volume 1. page 31. So it's volume 1, page 31 of the record. And let me just read it to you. So this was the application by the Human Rights Commission to get admission as an amicus before the full court, not before the SCA, not before this court. And this is what they said in paragraph 22, paragraph 22, page 31, volume 1. If the Human Rights Commission is admitted as an amicus, it proposes to make submissions on the following issues. 22.1. The cost that a respondent will face when defending an application in the High Court as compared to an application in the Magistrates Court. Sub 2, the impact that the additional cost will have on the debtor's financial position. Sub 3, the extent to which banks choose to approach the High Court when bringing applications of this kind rather than the Magistrates Court. This would entail putting up evidence regarding the systematic practice of banks. And then if I can ask you to be so kind, if you would go to page 242. Page 242, I don't have the volume number, unfortunately. But page 242, paragraph 6. You'll see a supplementary affidavit from the Human Rights Commission, where they say during a meeting between the DJP and the parties, the Human Rights Commission noted it intends filing an affidavit in response to the supplementary affidavits filed by the first, second, and fourth respondents. So whereas the earlier affidavit referred to submissions, the Human Rights Commission now made it clear they intended to file an affidavit. In other words, they were going to put up facts. Now, with respect, Justice Madlanga, members of the court, we don't have those facts. We don't have that evidence from the Human Rights Commission. My learned friend, Mr. Chaskelson, very fairly indicated that the Human Rights Commission made an attempt to do so, and there was an objection to admissibility. But the bottom line is, this court simply doesn't have any facts before it on which to draw inferences or which to draw conclusions regarding, is it in fact the case that 1 or 2 or 100 or 1,000 defendants would have defended had the matter been in the Magistrates Court, but didn't defend because the matter was brought in the High Court. There's simply nothing before this court.
Mr. Cockrell, I accept that, and I think Mr. Chaskelson has accepted that.
Yeah.
To the extent that legislation, and I refer in particular to the Legal Practice Act, recognizes that the cost of legal services is beyond the reach of most people. Is that a factor that this court could consider it all in the context of the access to justice argument? It's a recognition by the legislature of a particular state of affairs, and it proceeds in section 35, subsection 4 to make that recognition.
Yes, the only reason why I'm hesitating, Justice Collipin, is it's not apparent to me that the cost would necessarily be less in the Magistrates Court rather than in the High Court. So you'll know from the position of my client, Nedbank says, in fact, the costs are often less in the High Court than in the Magistrates Court because of the cost of appointing a correspondent in a Magistrates Court, which, Justice Majid, I think you said could be 800 kilometers away from the High Court in the Northern Cape. From the position of a defendant, someone who wishes to oppose, again, what Nedbank says on affidavit is, well, if you are looking for pro bono representation, you, the defendant, may find it easier to find that in a high court in a big city rather than in a far-flung area, for example, because that's where the societies of advocates are located, and you may find a legal clinic happy to assist you. So, Justice Collipin, the only hesitance I have in answering that question is that the real force of what you put to me is, would it be cheaper to defend in the Magistrates Court rather than in the High Court? And I simply don't know the answer to that, I'm afraid. And so, Justice Madlanga, members of the court, I'm about to conclude the third part of my address. For all of those reasons, the submission of my client is the judgment of the SCA is correct. The SCA asked itself, has the Constitution changed the law? It said it hadn't. In our respectful submission, that is correct for all the reasons I've advanced before you. And the criticisms of the SCA judgment by our learned friend in our respectful submission are unsustainable. And so we would submit that the application for leave to appeal should be dismissed, but certainly the appeal should be dismissed because the SCA was correct. But what if you disagree with me? And this is the fourth part of my address. In other words, what if you were persuaded by our learned friends that the SCA got it wrong? And the question then becomes, well, what would this court do? What order would it give? Now, ordinarily, what a court would do in this situation is it would reinstate the order of the full court. That's the order that was overturned by the SCA. But our respectful submission would be, even if you think the SCA got it wrong, certainly paragraph 1 of the order of the full court should not be reinstated. And this is the debate I had with Justice Patlantla earlier today. Let me just summarize. As we understand it, nobody before the court defends paragraph 1 of the order of the full court. Our learned friend, Mr. Chaskelson, argued the matter before the SCA. He made it clear he wasn't there to defend the order, paragraph 1 of the order of the full court. And today, again, very fairly, he conceded that something that would have to be done by means of a practice directive, but couldn't be done by a judgment of the High Court. Now, even if it were to be done by a practice directive, well, that may cure the defect of form, but it wouldn't cure the defects of substance. Let me just make some very brief submissions regarding why paragraph 1 of the order of the full court should not be reinstated in any form. The first is one you've already heard me on. As a matter of substance, paragraph 1 says, if you want to use the High Court, you can go and get leave, but the reasoning of the full court, in fact, means you'll never get leave because it's always an abuse. I'm not going to rehearse that submission. The additional points I want to make are these. Assume, let's take my client, Nedbank, were to go and ask a High Court for leave to sue out of the High Court rather than the Magistrates Court. And assume my client were to get leave to use the High Court.
Mr. Cockroach, if there are problems with how an order, a court order is couched, another court or the same court down the line may have to, if called upon, may have to engage in an exercise of interpreting that order. By making reference to the possibility of applying for leave, surely the High Court must be suggesting that it's not a case of you can never get leave. So how best can we make sense of that order?
Yes.
Rather than reading it the way that you are. You can never get leave.
Justice Belanga, I don't mean to be disrespectful to the full court, but when one reads the reasons clearly indicate it's always an abuse. And if it's always an abuse, it's difficult to see how a high court could ever give leave. So I suppose one would have to then read it generously as meaning you, Nedbank, take my clients as an example, would have to persuade a high court that you have legitimate reasons for using the High Court rather than the Magistrates Court. But the problem with that is you'll know from Nedbank's affidavit, they've already set out those reasons. They've set them out at enormous length. Why do they use High Court rather than Mag Court where there's concurrent jurisdiction? So the full court was aware of those reasons, but still said it was an abuse. So Justice Belanga, I do understand the question you asked me. I just don't know the answer to it, because if you are the High Court judge being asked to give leave to Nedbank, he or she is likely to scratch his or her head and say, well, I don't know why you are before me, because the full court has already found that you're abusing the process by using the High Court rather than the Magistrate Court. So I understand the conundrum. I just don't know the answer, Justice Matanga. But with respect, the submission we make is it would be better not to create the conundrum at all. But there are other reasons why the conundrum shouldn't be created. And let me just give you two very quickly. I'm almost out of time. The one is this. Go back to my hypothetical example. My client goes before a high court. It gets given leave. It finds a judge who doesn't scratch his or her head, gives leave to my client, Nedbank, to use the high court. If my client then succeeds against the defendant in that matter, well, the cost of seeking leave before the high court are going to form part of the ultimate cost order against the defendant. And so the perversity of it is, it may mean a defendant will end up paying more costs, not less costs, if he or she were to lose in the ultimate matter. Because the cost of seeking leave would simply be rolled up and would form part of the cost order in due course. So in that respect, the requirement to obtain leave is counterproductive. But I wish to make one other submission, and it is in the papers, and it's this. I make this submission no higher than this. Banks such as Nedbank, my client, are in the business of lending money. Sometimes loans go bad and they have to recover those debts. If, and I put it hypothetically, if someone like Nedbank or another bank were to form the view that it's very hard to get leave to use the High Court, and the magistrates' courts are largely dysfunctional for the reasons set out in the affidavit, therefore, because I will not be able to recover the debt if the debt is not paid in due course, I will not give loans to people in that category. That would also be counterproductive. In other words, paragraph 1 of the full court order would then harm the very people it's designed to benefit, because banks conceivably may form the view in future, because I can't recover those debts, I won't advance the loans at all in the first place. And so for all of those reasons, we would respectfully submit that whatever this court were to do, if it were minded to find that the SCA was wrong, we would respectfully submit that paragraph 1 of the full court order should not be reinstated. As regards paragraph 2 of the full court order, well, I had the debate earlier. You'll know that Nedbank's position is slightly different to that of the other banks. The other banks say that Rule 3922 is exhaustive of circumstances in which a matter can be transferred from the High Court to the Magistrates Court. My client says on affidavit that isn't its position. It doesn't have a difficulty with transfer as long as it's in the interest of justice, which means there must be a factual basis for it. In other words, I need to make this clear in the light of a debate that was had earlier in the day. It would, in our respectful submission, not be competent for a High Court judge simply to transfer a matter where there's no factual basis for it. It would at least involve a factual basis. Someone in Mr. Chaskelson's hypothetical example, the person who comes to the Kimberley High Court and says, I would defend in the Mag Court, but I can't defend here. In that sort of situation, Nedbank accepts that it would be competent for the High Court to transfer the matter to the Magistrates Court. But that may also require some panel beating with the wording of paragraph 2 of the order of the full court, but that is the position of my client on affidavit. Justice Madlanga, members of the court, subject to any questions the court may have, those are our submissions. Just to be absolutely clear, Nedbank asks that the application for leave to appeal be dismissed, but if the application for leave to appeal were to be granted, and we certainly accept that there are powerful issues that would justify the attention of this court, then we ask that the appeal be dismissed. If this court were to find that the SCA was wrong, our submission is that whatever this court does, it should not reinstate paragraph 1 of the full court for all the reasons I've given. And Justice Madlanga, obviously Nedbank doesn't ask for costs before this court. Justice Madlanga, I'm sitting apart from my team. May I simply ask for a similar indulgence? I'm guaranteed it won't be as long as my learned friend, but may I just check my phone to see if I've missed anything? Thank you.
Just a minute. Did I not hear Justice Majid wanting to come on or not? I thought one of my colleagues wanted to. Oh, I'm sorry. Yes, Mr. Cockrell.
Thank you, my lord. Justice Madlanga, I'm going to go off camera very quickly. Thank you, Justice Madlanga, members of the court. Those are our submissions. Thank you.
Thank you very much, Mr. Cockrell. Mr. Cillier?
Thank you, Justice Madlanga and members of the court. From our side, coming in as the third wheel, it seems a bit like the uncapped boy coming in the last 5 minutes of the game. But let me attempt not to bore the court with the repetition of arguments. We think that the proper point of departure should be to go to the core of what this matter concerns. Once again, it concerns the realization of Section 34 rights. From that premise, of course, in the present set of facts, the issue of the mandatory jurisdiction rule comes to the fore. What is quite interesting is that the Human Rights Commission does not attack whatsoever the statutory scheme by which effect was given to the Section 34 right and also Chapter 8 of the Constitution. That seems to be beyond reproach. What is rather under attack is the common law mandatory jurisdiction rule. And may we venture to say that coupled with that, there is an implication also of the rule that a plaintiff chooses the forum in which to litigate where more than one competent forums with jurisdiction are available. Against that background, and before turning to the specific areas of attack and the approach followed by the Human Rights Commission, as well as our answers thereto, First Rand Bank must make this quite clear. We do not hold the position that a court is not entitled, by reason of any common law rule, to refuse to exercise in a particular case the jurisdiction to hear a matter on the merits. What we mean in saying that is the following. Section 172 of the Constitution obliges a court to strike down any conduct or law inconsistent with the Constitution. Should it then, within the current context of facts, appear in a particular case-specific matter that there is an infringement of the Section 34 right of a particularly impecunious debtor or any other litigant, whether in the context of the facts proposed here by the Human Rights Commission or otherwise, then a court does not decline to exercise jurisdiction. What it does, in our view, is to exercise the jurisdiction on the basis of saying that the coming to this court infringes on a fundamental right. And therefore, we strike down the act of doing so. Against that background, then, we conclude this by saying, we do not think that issues should be conflated. The striking down of any conduct inconsistent with the Constitution is something quite different from the question whether a court is entitled to decline to exercise jurisdiction. If it strikes down conduct inconsistent with the Constitution, it exercises jurisdiction. Turning then to the present matter, what we deal with, firstly, is not this case-specific matter, where any facts are adduced from which the High Court could have made any findings of an infringement on Section 34 rights, whether by reason of geography considerations or lack of financial means. We deal here with no facts available to the High Court, no facts available to the SCA, and no facts available to this court, from which an adjudication can be made whether there was in fact an infringement in a particular case. Rather, Justice Madlanga and members of the court, the matter is approached from a more holistic basis. There is a stereotypical debtor and a stereotypical creditor that is postulated. And it is accepted as a factual premise that in the instance of the category or class of persons referred to as impecunious debtors, there would be an infringement on the fundamental Section 34 right, or there can possibly be such an infringement on the Section 34 right. Now that, of course, is problematic when one considers Section 34. We have referred in our heads to the fact that already in Barkhuizen, this court has preferred a subjective consideration of an infringement of Section 34 rights as opposed to an objective assessment. What the High Court did here was to make an assessment and to come to a conclusion against the background of objective assessment and not a subjective assessment. This particular issue has already, during the course of the argument, deserved some attention from the members of the court. Is this not a matter that has to be dealt with on a case-to-case basis? Absolutely. It has to be dealt with on a case-to-case basis. In saying that, of course, we do not deny that a real problem exists. It cannot be denied that impecunious debtors may very well have difficulties to access courts by reason of geography and by reason of financial inability. But that, of course,
Please continue. Please continue.
Thank you, Justice Madlanga. But that, of course, and we agree fully there with the argument proposed by Standard Bank, falls within the province of the legislator. What the legislator created is a system of concurrent jurisdiction. What it created is a system by which as many as possible courts are made available to litigants to adjudicate their matter. And understandably so, the Human Rights Commission, of course, does not attack whatsoever the constitutional validity of the legislative scheme. Rather, it opts to attack only the common law rule alongside the statutory scheme that makes it obligatory for a court to entertain a matter properly brought before it, subject only to an abuse. Now that, of course, is somewhat strange on the face of it. We say that for the following reason. It gives the fullest realization of the corollary right in Section 34, of course. Absent a court with competent jurisdiction being available to hear a matter, there is no possibility of a citizen realizing his Section 34 right. In those circumstances, it may very well be that no court is willing to hear a matter, and thereby it makes a mockery of the Section 34 right. That, of course, brings me to the attack by the Human Rights Commission. We make common cause with Mr. Cockrell for the second respondent Netbank to say it is quite difficult for us to really understand the case put forward on a legal theoretical basis by the Human Rights Commission. And it seems to me that they have understandably struggled with certain issues. We understand the matter, however, to be this. There are tiers of attack that are brought. First and foremost, it is the Section 1691 argument. We understand the argument to simply be that the word may used in Section 169 connotes a meaning of affording a discretion. Now, we make common cause with our learned friends for the first and second respondent that the word should not be read as must, but most certainly it can be read as no more than conferring a power. If any doubt on that score exists, I think the answer is to be found in the present set of facts and the order that was granted by the High Court. Our learned friends, Justice Madlanga and members of the court, referred to section 167, section 168, 169, and 170 of the Constitution. All of the
before you make your point on those sections, the 10 minutes is up, Mr. Cilliers. Please continue.
Thank you. If one has regard to all of those sections, the point has been made that in all of them, the word may is used. Therefore, it only confers a power. But I think the point is...
May I ask to take you back? Please hold your thought and don't lose your train of thought. May I take you to a very minor point, just for clarity? You said reliance, instead of subjective facts, reliance was placed on objective facts. Do I capture what you said correctly or not?
Justice Madlanga, if I use the word facts, I meant it's an objective approach that was followed instead of a subjective approach.
Instead of maybe I'm making the mistake. All right, please continue then.
If it was mine, I apologize to the members of the court. I think if I can just make that clear, there's no facts here on which a finding could be made.
I suspect I made the mistake, Mr. Cilliers. Yeah, you've clarified it. Thank you very much.
Thank you, Justice Madlanga. Justice Madlanga, just to return to the point that I wish to make, and I do not want to reiterate the arguments surrounding the use of the word may in all of the relevant sections in Chapter 8 of the Constitution. But I think what is important is to have regard to Section 170 of the Constitution that deals with other courts. Now, that includes, of course, the Magistrates Court. And what Section 170 says is this: all courts other than those referred to in Section 167, 168, and 169 may decide any matter determined by an Act of Parliament, but a court of a state is lower, and I don't think it's necessary to read further. The word may, of course, is employed there as well. We know that it is a primary rule of interpretation that one cannot interpret a statute to achieve an absurd result. And one cannot interpret it against a background other than to consider that Parliament had a purposeful object with the particular enactment. Now, if the word may is to be interpreted as conferring a discretion, then of course it means that a plaintiff may find itself before a High Court refusing to exercise jurisdiction, and similarly so, after referral to the Magistrates Court, to a Magistrates Court validly refusing to hear matter in the exercise of a discretion. Now that cannot be true, because that would of course fly in the face of the Section 34 right. Therefore, on a proper interpretation, the word may can only be read to be meaning that it confers a power. Now, from that point of departure, the Human Rights Commission seems to us say that once their interpretation of Section 1691 is accepted, then of course the mandatory jurisdiction rule is in conflict with Section 1691. And that should theoretically then bring the end to the inquiry. Of course, that interpretation can never stand. Therefore, they must pursue another avenue. It seems that they find solace then in Section 173 of the Constitution, as the High Court did. Section 173 deals with the exercise of an inherent jurisdiction. Now, of course, we know from the body of authority from this court that in exercising the inherent jurisdiction, two distinctive factors come to play on our understanding. The first, of course, concerns the regulation of process. That issue has been canvassed. I will return to dealing with it a bit later. But the second issue concerns the development of the common law. Now, when one deals not with regulation of process, but with the development of the common law provided for in Section 173, it must of course be read with the provisions of Section 8.3 of the Constitution. I will now return to just dealing for one moment with the regulation of process. It seems that our learned friend for the Human Rights Commission, in his argument, proposed that the High Court can deal by way of a directive with the issue, which seems to us to suggest regulation by process in terms of the power conferred in Section 173. Now, of course, that can only, and the authority in this court is quite clear, be exercised in circumstances where there is a lacuna in the legislation. One then has to ask oneself, is there a lacuna in the legislation? The Human Rights Commission, in its heads, proposes that the lacuna exists in Uniform Rule 3922 because the court is not empowered to mere motor transfer a matter.
Is it not unduly restrictive to say that the inherent power may only be exercised where there's a lacuna?
It is not the only
under situations where there may be provision, but the court may feel that we are not going to follow those provisions because in the particular circumstances of this case, it makes practical sense for us rather to do this instead of that. Would that not be covered? And is that necessarily a lacuna also for the court saying for practical reasons we will do like this when the entire terrain is, so to speak, covered by provisions, whether in terms of an act or the rules?
That is precisely the point that I wanted to arrive at, Justice Madlanga. They say that there's a lacuna, but there is no lacuna. And that is an answer to your question. Uniform Rule 3922 designedly says and prescribes that it is by agreement between the parties that a court can transfer the matter to a magistrate's court. Now, we say that is a designed structure of the Act by the legislator to recognize the right of a plaintiff to choose the forum in which to litigate. It is no lacuna, it is a deliberate enactment, excluding it. One can see, for example, confirmation of this in Section 27 of the Superior Courts Act that deals with the transfer between courts on the same level to high courts, where it can be done on application by a party. Here, an application by one party is excluded. And why is that so? We say it can only be because the legislator took account, when enacting the rules, of the common law right of a plaintiff to choose the forum, and where one deals with a transfer from courts in different hierarchies of the court structure, from the High Court, therefore, to the Magistrates Court, the plaintiff's consent is required in doing so.
Mr. Salia, if I may stop you, isn't that plainly too restrictive? Why would it not be the case, as I think Mr. Cockrell has submitted, that in a proper case, for example, Mr. Chaskelson's example, a court could and should, in certain circumstances, transfer because otherwise access to courts is going to be imperiled?
Justice Unterhalter, I agree with that submission fully, but on a different basis. And that is why I started out in my address to this court to say that where one deals with a particular case-specific matter, where there is an infringement of a fundamental right, and we talk about the Section 34 right, a court is perfectly entitled to make an appropriate order and to transfer that matter or to make another order that is appropriate. But that, we say, is something different. That is where a court is confronted with a specific instance of an infringement of the fundamental Section 34 right in a specific case. And that would, of course, on a different basis, entitle a court to transfer the matter or to make another remedial order.
Well,
that is something.
Even apart from that, why shouldn't an application be made by a defendant to transfer? Why should it require consent?
It is, from our perspective,
isn't it just a discriminatory rule without proper point?
We submit no, Justice Untitled. We think that the rule, as it stands, was enacted having in mind the right of the plaintiff to choose the forum. Whether that rule should be changed, or whether it is a better approach that a court can mere modo transfer a matter, that of course is, we say, not within the power of a court to decide, unless it is inconsistent with the Constitution.
But why is it preventing the plaintiff from choosing the forum to approach in the first instance if there are nevertheless important considerations that upon application by a defendant would suggest that another court is the better forum to hear the matter?
Well, Justice Untitled, the best answer that I can give is the rule as it is. As a matter of principle, we agree that it should be open to a court to, on application by any party, consider the issue.
Yes.
Currently, as the rule is framed, it of course does not provide for that.
Yes, thank you.
Thank you, Justice Untitled. Justices of the court, returning then to our submissions to you. If one has regard to Section 173, we say there is no lacuna and there is no basis upon which the inherent power could be invoked to regulate process as the High Court did. The real and true question here, to our mind, concerned the development of the common law. It is a common law rule, as we know, that the manatee jurisdiction principle exists. What the High Court purported to do was to change that common law rule. Now, that can, of course, only be done once again with reference to Section 8.3 of the Constitution. In the present instance, we say that given the legislative scheme as it currently stands, the Section 34 right is fully realized. And there is no need to develop the common law rule that a High Court must entertain a matter properly brought before it and where it has jurisdiction. Where we think we differ from the approach by the first and the second respondents is this. Once a court is confronted with a particular matter brought before that court, competently so and properly, then it is not an issue of a discretion by that court to entertain the matter or to exercise jurisdiction if in a particular set of facts it declines to hear the matter. We say that for this reason, and we think it is an important distinction. If a matter is properly brought before a court and facts are placed before that court that another court would be better suited to adjudicate on the substantive disputes, and the court considers that the court indeed exercises its jurisdiction and it pronounces on the fact that another court would be better suited to hear it, or to say that on the particular merits of the matter, it will not hear it by reason of an infringement of rights or another proper and valid reason, but it concerns an exercise of jurisdiction.
Do you say that Agriwa was too categoric in saying in all circumstances our law does not contemplate forum non-conveniens as a basis for declining or declining to hear a case, or perhaps considering another forum to be a better place for the dispute to be determined?
I think it is, it was stated quite succinctly, and in those succinct terms, a bit too harsh, but we take the following view. Once it is relaxed, it must be done with caution. Because if it is not done with extreme caution, one can have quite the opposite startling effect, that the Section 34 right is implicated by too wide a discretion given to a particular presiding officer, either in the High Court or another court. One must bear in mind, in our view, Justice Unterhalter, that Section 34, or rather the corollary right in Section 34, of course, concerns at its heart the access of citizens to a court. And once it is left in the province of a presiding officer to decline to exercise the jurisdiction, we tread dangerous territory.
Well, let's not use the language of decline. Let's rather simply say a court determines that another court is better placed to determine the matter. Do you recognize that a high court would have that competence upon a proper case being made to it?
I think so. I think it does. In a particular case, yes. As a general proposition, as the High Court did here, of course, we take quite a different view. But on a case-specific basis, yes, and there can be various reasons for that. And may we make our position just plain, Justice Unterhalter. Whilst I would concede that the court would have the power in a particular case and in a particular set of facts to adjudicate upon a matter in the sense of saying another court is better suited, like one would have in the committee matters. It is important that a proper basis must exist for doing so. One cannot simply abolish the right of a plaintiff to choose the forum in its entirety. One immediate issue that comes to mind in the particular matter that serves before this court today is an infringement on a fundamental right. If I may return to the example that Mr. Chaskelson has given, if that defendant can show to the court that it would indeed be an infringement of his right to access to courts if the matter is heard in Kimberley, as opposed to 800 kilometers or 600 kilometers from there in a magistrate's court, that would be the typical case where a court, in fact, we say employs Section 172 of the Constitution to say the bringing of the proceedings in the High Court here is conduct inconsistent with Section 34 of the Constitution. And for that purpose, they decline to hear the matter and rather transfer it to another court.
Yes, I think I have your submission. Thank you.
Thank you, Justice Unterhalter. In essence, if one return to the order by the SCA, the question was asked whether the order by the SCA is not too narrowly drafted, is it not too rigid? And may I ask that we just for a moment consider at page 499 of the record, that is volume 6, the first order by which it replaced the High Court order. It is worded thus: the High Court must entertain matters within its territorial jurisdiction that fall within the jurisdiction of the Magistrates Court, if brought before it, because it has concurrent jurisdiction with the Magistrates Court. Now, that was, of course, in an answer to the question posed in the proceedings before the full court. We say that if one reads that order, and the same applies to the second and the third of those orders, within the context of the judgment itself, it certainly does not connote a meaning to exclude, one, the refusal by a court to hear a matter in circumstances where there is an infringement on a fundamental right. That is not what this court was concerned with in making the order. Second, it does not propose to say that in cases of abuse of court process, a court cannot decline to hear the matter. That is not what the answer was concerned with. Therefore, First Rand Bank.
Mr. Cilliers, we are 1 minute beyond the deadline, your deadline. How much more time do you want? No, not at all.
1 minute, 1 minute before I just ask my learned junior whether one or two issues should be addressed. We would therefore ask that the application for leave to appeal be dismissed. It would not be in the interest of justice to grant leave to appeal in circumstances where there is no prospect of success in the appeal. But if the court is not with us on refusing leave to appeal, then we would ask that the application for leave to appeal be dismissed and that the order of the SCA not be interfered with. There is no difficulty with the order. If the court is inclined to consider reverting to the High Court's order, we make common cause with the submissions made by Nedbank. Most certainly the first of those orders can never stand scrutiny and muster. If I may just have 30 seconds to take an instruction, Justice Malanga and other justices. Thank you, Justice Madlanga and other members of the court. Just two issues quickly. The first is, with reference to the 12 matters of which 11 remain, we make common cause, of course, with the submissions by Standard Bank, that the mere fact that the arrears were paid most certainly is not indicative that there was a valid defense in those matters. We find it difficult to understand that submission that was made by the Human Rights Commission. Second issue concerns the argument surrounding the interpretation of section 1691 of the Constitution with reference to the use of the word may. Our learned friend for the Human Rights Commission in argument supported his argument with reference to the fact that the Supreme Court of Appeal and this court can refuse to hear matters in certain instances, and that would be indicative of a discretion conferred in section 169, also on the High Courts. Over and above the submissions that you have already heard, it is important, we think, to take the following into account. Once a matter is taken on appeal, whether it be to the Supreme Court of Appeal or to the Constitutional Court, the section 34 right has been realized already. Then those litigants had their access to the High Courts, and it is only access on appeal that is relevant. And therefore the legislator, as Justice Mayit quite correctly, we think, pointed out, set the certain barrier before entrance can be obtained to have a matter heard on appeal. The same applies, of course, to an application for direct access to the Constitutional Court. The legislator provided the barrier. Therefore, we agree that the comparison between the barriers placed in the case of appeals or a direct access to the Constitutional Court and access to the High Court are misplaced, there is no parity of reasoning. We would therefore ask that the relief as I've set out, and there's no order of cost that we see. Unless there's
Mr. Salir, if I may just detain you for one moment, if I may. Do you have the Superior Courts Act with you?
I can quickly put my hand to it, Justice Untitled.
I wonder when you have the act, if you just turn up section 8.3.
I apologize, Justice.
No. Take a moment to get the statute.
This is Untitled. Can I just, yeah, there we've got it. I have section 8.3, Justice Untitled.
Yes. Section 8.3 confers a power on the Chief Justice, which he may in certain circumstances delegate, to issue directives, amongst other things, concerning the efficiency, effectiveness, and functioning of the courts. Is there anything that would prevent the Chief Justice or a Judge President from issuing a directive that said we are too burdened with matters coming from that could otherwise be heard in the Magistrates Court, and under some directive, either rationing the number of matters that come to the High Court, or indeed creating some regime, as I think Mr. Chaskerson was indicating, under which matters would come on a much more selective basis under some objective criteria to the High Court when the Magistrates Court was available. Are you saying, or just to pose the question, or are you saying that the common law jurisdiction, the common law rule on mandatory jurisdiction would preclude issuing a directive of that kind?
No, we do not think that that would preclude that directive whatsoever. We do not think that is what is applicable for a consideration. So to answer the question, Justice Untitled, as a matter of principle, the Chief Justice is of course empowered to do as is prescribed in section 8.3. Those directives must, however, in our view, not impact on legal rights. It cannot take with those factors listed there.
I'm sorry, Mr. Salir, the connection broke for a moment. Won't you just repeat that sentence? I didn't hear exactly what you were saying.
My apologies, Justice. Rather, I saw that my connection was unstable for a moment. What we say is, of course, the Chief Justice can issue directives validly under the empowerment to him with regards to those aspects mentioned in section 8.3. What we say cannot be done is that the Chief Justice cannot issue directives that would either take away existing legal rights or that would give legal rights to a party.
Well, let me give you a concrete example. Assuming the directive said that only 20 such matters will be allowed onto the roll in any given week.
That is purely a procedural issue. Whether it will create a number of difficulties in practice, that is something else, but that will be perfectly within what can be done. But to exclude the possibility to approach the High Court would take away an existing legal.
And if the directive said the matter must concern some aspect of complexity of either fact or law to come to the High Court, would that also be competent?
I do not think that that would be competent, because I think that is to encroach upon the place of the legislator, and that would infringe the separation of powers principle.
But the legislature has given the Chief Justice this competence. How is it tranching upon the separation of powers?
No, but it does not give the power to say that only in matters in complex matters the High Court can be approached. That is not the power that is given here. The legislature,
where there is an alternative to go to the Magistrates Court, it's not shutting anybody out. It's just saying we've got limited time, limited resources. This was Mr. Chaskelson's argument, though he didn't group it under the competence in Section 8. He said judicial time and resources in the High Court are limited. We have to have a system of rationing. Isn't this the power that can be used to effect that?
We think that in the example provided, Justice Unterhalter, just by you, it cannot be exercised in that way, because that would take away an existing legal right. That goes beyond a mere process ruling or directive by the Chief Justice, and that would go beyond the power in Section 8.3. The first example, of course, we agree with. If it organizes the number of matters that can be placed on a day, that falls within the ambit of Section 8.3.
Yes, thank you.
Thank you, Justice.
Thank you, Justice Madlanga.
Thank you, Justice Madlanga, and members of the court. Subject to any further questions, those are our submissions.
Thank you very much, Mr. Thilier. Yes, Mr. Lowe?
Thank you, Justice Mlonga. Justice Mlonga and members of the court, just the household issue first, if I may be allowed to do so. We have a condonation application to be allowed as amicus curiae. There was some misunderstanding. We were always under the impression that we are allowed, but it correctly, in the end, it appears that we did not have that right.
May I just ask this, Mr. Lowe? Are there any counsel who have any objection to the condonation application?
There was no objection.
It seems not. Please, we will consider the application, Mr. Lowe. Just please address the merits.
As it pleases your lordship, we would ask, just for the record, we would ask for prayers 1, 2, 3, and 4 of the notice of motion in that regard. Then, if I might turn to the issues, if I may address the members of the court, firstly on the last item that came up, the question of Section 8 of the Superior Courts Act. We agree with the submission of Mr. Sillier that it would not be open to the Chief Justice or to a Judge President to give a direction of the nature that that all cases or some cases, depending on the importance thereof or the amount involved on whatever basis, that they can be excluded and must go to the Magistrates Court. The basis for the submission is the following. There's an hierarchy of legislation here. Firstly, there is the Constitution, that is the supreme law. Subject to that, the next level is the Superior Courts Act. Then, thirdly comes the rules of court, which include Rule 3922. And then after that would follow the directions that may be made in terms of Section 8(3) of the Superior Courts Act. In other words, on that various levels, the last level is the question of the type of directive that can be given. And with due respect, powerful as the Chief Justice might be, or the Judge President of a particular division, they would not be entitled to change the law as it stands. In other words, that the issues of jurisdiction on the basis of the legislation that says which courts may hear what matters cannot be changed by way of, if I might call it so, a decree of that nature. Simply because that would mean that the body that is entitled to make such decisions as to jurisdiction, for instance, namely Parliament, or the Rules Board, as we may call it, the delegee of Parliament, are then excluded, and the polycentric issues that might arise are not taken into account, or probably not taken into account. So our submission would be, we agree with Mr. Sillier that that type of, by this type of decree, there cannot be a conference of jurisdiction or an exclusion of matters on the basis of, although there is concurrent jurisdiction in terms of the existing legislation, it can be taken away by a practice directive. We submit that that's not possible. If we may then turn to the order that was made in the High Court. Now, it seems for the moment that the applicant does not rely on and does not wish to have that order reinstated as it stands.
The 5 minutes is up, Mr. Lowe. Please continue.
As it pleases you, my lord.
Mr. Lowe, before you go on to the point, might I just return to the first submission that you made, just so that we can test what you're saying there? Do you say that the exercise of the power of making a directive is somehow, as I understood your argument, repugnant to the conferral of jurisdiction that Parliament has dictated otherwise upon the High Court? I'm trying to understand the source of repugnancy, though. The power is given to entertain a particular matter through a directive. The court, the Chief Justice or the Judge President says, well, I'm going to apply some criterion of rationing. I'm not changing the scheme of jurisdiction. I'm just applying, for reasons of the sensible use of court resources, a criterion to ration. Why is that repugnant to what Parliament has conferred, either under the statute or worse still, repugnant to the Constitution?
In terms of the Constitution and in terms of the legislation, there is concurrent jurisdiction between the High Court and the Magistrates Court, to put it bluntly. And that cannot be taken, that right of a litigant to have his matter heard under the concurrent jurisdiction, either by the High Court or by the Magistrates Court, cannot be taken away, as it were, by a decree in terms of a practice directive. That's our.
But it seems that at least your colleagues are recognizing a number of circumstances in which a proper case can be made, where the High Court would transfer the matter, where there may be an infringement of right, where there may be an abuse of process. Now there is a power given to past directives to ensure the efficient operations of the scarce resources of the High Court. Why is that somehow an impermissible carve-out, whereas the others are not?
Justice Unterhalter, the answer to that is on the higher levels. Once again, it's the legislation and the common law as it exists. Whereas in terms of Section 8.3, a certain amount of jurisdiction is given to the Chief Justice to make practical directions, but that cannot entail that the legislative regime of concurrent jurisdiction can be done away with on a basis of because the Gauteng High Court is overburdened. I'm going to ignore the fact that there's a concurrent jurisdiction provision and say that all cases that fall within the Magistrates Court's jurisdiction in the area of jurisdiction of the Pretoria High Court must go to whatever Magistrates Court has to.
Last question on the score. Would you recognize a distinction between rationing and divesting the High Court of competence to hear cases?
The rationing, Justice Unterhalter, in the circumstances would effectively come down to a taking away of a right that's conferred by way of the legislation and the common. I would submit that there's a nuanced difference between rationing and taking away the jurisdiction, because on a blanket basis, the practice directive would say these cases must go away, whereas the legislation applicable, the higher level of legislative measures, say you can choose which of the two courts. We agree, if I may immediately go on to the question of exceptions. We agree that there can be exceptions. Once again, the issue of an infringement of your Section 34 right of access to courts. If that is infringed in some form or fashion, then by reason of the Constitution, because there are not necessarily other legislative measures that would help there, purely on basis of the Constitution and the constitutional right that your right to access to court may not be infringed, the High Court would have the jurisdiction to say, but this matter must be transferred. The example of the person in the Northern Cape that's 800 kilometers away from Kimberley might be a good example for that type of situation. So yes, we also agree that that would be possible. As regards a general right to transfer matters between courts, we submit that that cannot be that easy. And if we may refer the justices to our heads of argument, it's from page 27, paragraph 11.7 and 11.8. We deal there with the various legislative measures entitling parties to transfer matters. And we can sum it up that Section 35 of the Magistrates Court Act makes provision for transfer of cases between magistrates courts. Section 50 of that Act makes provision for the removal of actions from the Magistrates Court to the provincial or local provision, but that's at the instance of the defendant. And the section deals with the case where a defendant has a counterclaim that exceeds the jurisdiction of the Magistrates Court after the plaintiff in that matter had instituted a matter that's within the Magistrates Court's jurisdiction. Then the defendant is entitled to have the matter transferred to the High Court, and the matter is proceeded with in the High Court in terms of the provisions of Section 50 of the Magistrates Court. Rule 3922 is the next issue that we dealt with. Rule 3922 simply says that a matter may be transferred by agreement. It does not allow for a unilateral decision. It is an agreement decision between the parties. And Section 27 of the Superior Courts Act only makes provision for transfers from one division to another, or from one seat to another decision. And therefore, we say that a general right to transfer cases between courts in terms of that legislative regime that we now referred to a moment ago is not available. You would have to comply with that's what the legislature once again legislated, how and when you can transfer. So except for those cases of the abuse or the infringement of your Section 34 right of access to court, we submit that there does not exist a general right to transfer. Now, that would be our submissions on that question. But if the court would just allow me a moment. Yes. If in that context, I think it is appropriate that we refer the court to Section 171 of the Constitution, which then says regards court procedures. All courts function in terms of national legislation, and their rules and procedures must be provided for in terms of national legislation. If we may then proceed to a second issue. Justice Malonga and members of the court, the order of the High Court as it was made, and if I may request the court to have regard to the orders as they were made, either at, I would use page 425 of the record, it's in volume 5. The first order that was made by the full court was to promote access to justice as from 2 February 2019, civil actions and/or applications where the monetary value claimed is within the jurisdiction of the Magistrates Court should be instituted in the Magistrates Court having jurisdiction, unless the High Court has granted leave to hear the matter in the High Court. Now, we made our submissions with regard to the right to transfer, and I'm not going to go back to that. But if the court has regard to the general wording of paragraph 1, that wording entails that literally all cases within the monetary value of the Magistrates Court gets transferred. It's not limited to the type of matter that was the subject of the hearing before the full court, which are limited to home loan type of agreements and National Credit Act type of cases. So if in any form or fashion, the first prayer of the order remains in place, it would mean that a general transfer is going to take place, at least, well, generally in the country, if the court makes a decision that falls in line with the approach in prayer 1 of the judgment of the full court. And we submit, well, firstly, the matter did not deal with anything but the limited cases in the broadly put credit type of agreement area, and it did not take into consideration any of the issues that would arise from cases, and we refer to that in the heads of argument, the questions that would arise, for instance, in unlawful arrests, even medical type of cases that arises where a party, although the amount might fall, the claim amount might still fall within a magistrates court's jurisdiction or a regional court's jurisdiction for that matter, still might decide to go to the High Court. And it's a matter of common knowledge that in many of those instances, although an order is made within the magistrates court monetary jurisdiction, costs on a high court scale are granted for, and we referred to one judgment in that regard, just by way of example, if we may direct the court's attention to that. It's the matter of it's the matter of Mate versus the Minister of Police. It's in the Safley cases, and we gave the reference in our heads of argument with regard to that type of case. So what the amicus wishes to warn against is, on a simple reading of the judgment of the High Court, if it stands as it stands, it's going to have a much wider import, we respectfully submit, than the facts that were dealt with, or whether we call it the facts or the lack of facts. The fact of the matter is, what was dealt with certainly was not all cases and any type of case within the magistrates court monetary jurisdiction. So in those circumstances, we would submit that purely on that ground, the order of the High Court, the full bench of the High Court, cannot in some form or fashion return as an order.
Mr. Lowe, your time is up. How much more time do you want?
The Lord, I think I will be able to do it in, maybe let me rather be careful, 5 to 10 minutes, if you would allow me.
No, I'll tie you to 5 only, Mr. Lowe.
As it pleases you.
See how you do it, but end of 5 minutes, that's it, please. Thank you.
Thank you. Then we need to refer the court to the question of, there's much said about the access of indigent defendants to justice. Once again, the Constitution says a party, a person is entitled to have his matter heard by a court, or may I just broadly call it a similar type of institution. It need not particularly be a court. Then, particularly in the relevant type of cases that served before the High Court and that gave rise to the judgment of the High Court, were in the credit agreement type of environment. And under that legislation, there are a plethora of alternative dispute resolution processes that allows for a hearing on whatever issues there are, and that as a fact states that there are not costs orders made. The general rule is that each party there is obliged to pay its own costs. And in terms of the consumer courts that exist, an indigent defendant would even be assisted by the personnel of those courts to get a proper hearing for his or her gripe with whatever was his defense against a claim by a bank or other company. So we would submit that, having regard to the whole question of alternatives, of the right to put your case before the court, there are sufficient alternative arrangements that show that the approach of the applicant, that there must be this rigid, well, I think our colleagues this morning took a little bit of a different approach, but the general approach that matters that actually fall within the Magistrates Court jurisdiction must be referred to the Magistrates Court, because otherwise the defendant would lose his right to a proper hearing. We would submit, in the general context of specifically credit agreements type of cases, that does not apply. Before any plaintiff, in terms of either loans or motor vehicle transactions, can sue out of court, they have to give the defendant an opportunity to refer the matter to alternative dispute resolution processes, which in this instances also did not happen. So it must be assumed that those defendants simply did not have a defense, otherwise they would have done something. May I just hear from my juniors if the court would allow me also a short second to take in what my colleagues wish to say. Justice Mlanga and members of the court, would you allow me one item of comment? The question was raised: how should the Supreme Court of Appeals order be amended?
And how much time do you want for that point? 1 minute. One minute, Justice. Thank you.
We would submit that Prayer 1 of the Supreme Court of Appeal order, if it should be changed, can be suitably amended by, at the end thereof, after, in other words, the reference to Magistrates Court, comma, and then added subject to cases where abuse of cases where there are abuse of process of court. Those are then our submissions.
Thank you very much, Mr. Lowe. Mr. Shaskalson.
Justice Madlanga, Justices. There are 6 points that I want to touch on very briefly in reply. The first is to clarify the ambit of our concession on the facts. The second is to note the apparent general consensus on a need to qualify the agri-wire principle, and we submit the concomitant need to qualify the SCA order. The third is to engage with the subsidiarity argument that has been launched against us. The fourth is to deal with the argument that the mandatory it's for Parliament, not the courts, to make any changes to the mandatory jurisdiction principle. The fifth is to deal with the suitability of a practice directive to address the underlying problem that has given rise to this case. And finally, to suggest what modifications are necessary to the Supreme Court of Appeal order in the light of all of these submissions. And I'll be relatively brief in all of these. On the ambit of the concession of facts, there are facts that we do still rely on. I've traversed most of them in my principal submissions, but I just want to emphasize again, in 7 of the 11 relevant cases that were brought before the High Court and that would have proceeded to default judgment, including an order declaring property executable, but for the intervention, 7 of the 11, the cases were subsequently withdrawn without any order declaring the property to be executable. That suggests that there is an access to court problem here, that the ability of the debtors in these cases to come to court and say, I can restructure my affairs, I can pay back, don't take my house, only came to light because of the particular attention given to these cases as a result of the directive, the appointment of the Society of Advocates in Pretoria to consult with the litigants. And but for that process, there would have been orders declaring homes executable, which the banks are now apparently happy to do without. That's an access to court problem. The second fact on which I would rely is the fact set out at paragraph 43.1 of our heads, which are magistrates' courts are generally much more accessible physically. There are 82 regional courts, 468 district courts, with the aim of at least 1 district court for each municipality. There are only 12 high courts. So it's safe to assume that magistrates' courts are closer and less costly to appear in as an unrepresented impecunious accused, because you don't have to deal with transport and accommodation costs. The third fact on which we would rely are the facts set out at paragraph 43.5 of the heads relating to interpreters. Magistrates' courts are more accessible because they have interpreters. So for most unrepresented defendants in this country, magistrates' courts are more accessible. They have people who will enable you to speak your own language in the court proceeding. High courts don't have interpreters. I don't suggest that these facts show that in every case a hearing in the High Court will violate the fundamental right of access to court if it could have been brought in the magistrates' court. But I do say that these facts are material facts, and that certainly for the purposes of deciding what default rule to apply in any practice directive that may ultimately be issued, the Chief Justice or a court head issuing that practice directive would be entitled to assume that ordinarily a functional magistrates court will provide an impecunious and unrepresented debtor better access to court. The second point that I wanted to address was the need to qualify the agri-wire principle. Unless I misunderstood our learned friends, I didn't hear any of the representatives of the bank disputing that in circumstances where there is evidence that to proceed with a case in the High Court would be to violate the access to court rights of the defendant, the High Court should not be precluded, should not be obliged to proceed to finality. To take the Kimberley example that I kept bandying about, nobody appears to take issue that it would be unjust and I would submit unconstitutional for a High Court to hear the case to finality in those circumstances. We submit that that means this court needs to make that clear and to qualify the agri-wire principle accordingly, and also concomitantly to qualify the SCA order, which is framed in very extreme terms of its own along the lines of agri-wire. And
sorry, Mr. Chaskelson, could I ask you, is the sealing of the qualification a violation of the Section 34 rights, or could it be wider than that to encompass the interests of justice?
My submission is that it would go wider, but my ultimate submission is that the place to deal with these issues is in a practice directive, which will be of legislative nature. But it does, for the purposes of principle, certainly a violation of the access to court would axiomatically be a problem and would not be permissible. I would submit also that in circumstances where the effective functioning of the High Court in question is being compromised, that goes to issues of judicial independence, as we've set out in our heads. And in those circumstances, the agri-wire principle would have to yield to the needs for judicial independence, the needs for effective functioning of the High Court. In relation to the subsidiarity argument, we heard a lot of submissions that we should not look to the Constitution for jurisdiction, we need to look to the statutory regime. But if we do look to that statutory regime, the statutory regime doesn't contain any provision at all requiring the High Court to exercise jurisdiction that it has. Nowhere in the statutes will we find a provision that says the High Court must exercise the jurisdiction that it has, or the High Court must exercise this jurisdiction. So with respect, the subsidiarity argument doesn't take the case of the respondents further. What the respondents' case ultimately rests on is the mandatory jurisdiction principle that is a rule of the common law. We've got to look to the common law there. And there is, in that respect, on the mandatory jurisdiction principle, a contradiction running through the heart of our respondents, of our learned friends' arguments. It's common cause that the mandatory jurisdiction principle is a common law rule. It's not a statutory rule. So it is judge-made. But our learned friends say only Parliament can change it, because to change it would require polycentric determinations that judges cannot make. But that makes no sense whatsoever. If judges made the rule with all of its polycentric implications, why can't judges change it? We submit there is no answer to that, particularly when the rule in its current form goes to issues that implicate the institutional independence of the judiciary. And that's a point that we have emphasized at paragraphs 21 to 23, 21.1 to 21.3 of the heads of argument, that institutional independence of the judiciary requires that judges have control over administrative decisions, quoting from Valente, paragraph 21.1 of our heads. The institutional independence of the tribunal with respect to matters of administration bearing directly on the exercise of its judicial function. And it requires judicial control over administrative decisions that bear directly and immediately on the exercise of the judicial function. These are decisions that do so. The decision that a high court must hear every single magical jurisdiction matter that is enrolled before it is going to implicate the ability of that high court to do justice in the matters for which it has to do justice and for which there are no alternatives. I refer merely to the passages in Valente that we cite in 21.1 to 21.3. So we submit that if the original mandatory jurisdiction law was judge-made, there is nothing to stop judges changing that mandatory jurisdiction law. There's nothing that requires judges to wait until Parliament changes it. They made it, judges made it, judges can change it. But we have repeatedly conceded that the appropriate way for any changes to the mandatory jurisdiction rule to be made is not by an individual order, it's rather by a practice directive. And we stand by that concession. And I want to emphasize that a practice directive is not the same as an order. And there are three important differentiating facts in this regard. The first is a practice directive is made by a process that is not individualized and confined to parties to an individual case. It is going to be made by a public notice and comment process. So it's much better suited to making determinations of a legislative nature. The second is it has to be published in the Gazette under Section 8.5 of the Superior Courts Act. So if a practice direction is made, it's out there, published, everyone can find it, everyone can know where they stand in relation to any new default rules. And finally, if there's any doubt as to the authority to change the default rule through a practice directive, there is express authority that Justice Unterhalter pointed to in Section 8.3b, which authorizes the issue of practice directives regarding any matter affecting the dignity, and I would emphasize accessibility, effectiveness, efficiency, or functioning of the courts. Those are precisely the issues that are implicated by the problem that we are grappling with today, and those are issues that could quite legitimately fall within the ambit of a practice directive under Section 8.3b, changing the mandatory jurisdiction rule where appropriate, so as to free up the roles of the High Court and to promote access to justice in the Magistrates Courts. So then in conclusion, Justices, we submit that the order of the SC, that leave to appeal should be granted, that the appeal should be upheld, even if only to the limited extent of modifying the order of the SCA, to make clear that the High Court is not obliged to hear cases in which there is evidence showing that to require the defendant to have the case heard in the High Court, as opposed to the relevant Magistrates Court, would violate the defendant's fundamental right of access to court. On its face, the current order of the SCA suggests that High Courts have to insist on hearing to finality those cases. At the very least, we submit that is clearly wrong. We would submit further along the lines of my engagement with Justice Collipin that in any circumstances where issues of the independence of the High Court are implicated, the High Court is not obliged to hear cases within the concurrent jurisdiction of the Magistrates Court if to do so would impair its efficient functioning. Finally, we would submit that although it's not for an order, we would ask this court to make clear in its judgment that it is possible for a practice directive to be issued, possible and indeed desirable to resolve this problem through a practice directive, and that a practice directive could be issued limiting the Magistrates Court jurisdiction cases that a High Court is obliged to entertain if that is necessary to promote the accessibility, effectiveness, efficiency, or functioning of the Magistrates Courts and the High Court. Those then are our submissions, Justices.
Thank you, Mr. Chesterton, and thank you to all counsel. Judgment is reserved. Court adjourned.